Please, you know, information for listing a IA. Lordship, it is filed on 10/1, Lordship. Will they listed
I for what?
for substitution of parties, Lordship?
Okay, it will be listed next week for you.
May I please, your Lordship? Lordship, I am praying for listing of an unlisted motion, my lord. My lord, hearing this case on 3rd of February, my lord, I was issued a notice by the executive engineer, my lord, Borpata Road Division, my lord, for demolishing my boundary wall, my lord, within 3 days, my lord. So the notice was issued on 3rd of February, my lord. And my lord, today, if no order is there, tomorrow they will demolish my boundary wall, my lord. It is there in my Patta land, my lord.
Okay.
Today, my lord. I'm deeply obliged, your Lordship.
Please, your Lordship. May I pray for listing of a writ petition, Lordship? Matter pertains to transportation of coal, Lordship. I have ordered the matter on Friday, Lordship.
It will be listed.
Thursday.
Motion matter, it will be not Thursday. It will be listed. This matter will be listed next week, Lord.
Lord, I'm praying for listing of a fresh writ petition, Your Lordship. It was filed on 24th of January. Objection complied by 30th of January, Your Lord.
Tomorrow?
Much obliged.
May it please your lordship, in item number 3, my lord, 4, as per earlier instruction, I need to file the affidavit. Today that affidavit have reached, but it is one signed copy has been signed, my lord. So I am not seeking for adjournment. If need be, kindly accommodate it till Friday, my lord.
Okay.
As I could not, in fact, inform the other sides also.
So you have informed the other side.
No, I have not yet, my lord.
Okay, let them come.
Yes, my lord.
For withdrawal, item number 14.
You
You
want
may
to
be
talk?
allowed to, yes, man.
Mr. S.K. Deori, Learned Counsel for the petitions, has submitted, comma, on instruction, comma, that the petitioner wants to withdraw a petition.
I'm asking for the
Mr. P.J. Soike, Learned Senior Counsel, assisted by Mr. R.K. Talukdar, Learned Standing Counsel, NHIDCL, for the respondents are in attendance. In view of the above submission made by Mr. Deori, the Learned Counsel for the petitioners, the petition is dismissed on withdrawal. Same.
Apply.
For motion, item number 2 and 3.
Mojumdar, MS Mojumdar, we'll take up after motion. After motion.
Yes.
Items 2 and 3.
Possible the matter for the timing, your lordship. Apology, your lordship.
Top of the list, item number 1.
May I please, your Lordship?
1 minute. Let me organize. Contract. Okay. Very good. एक मिनट पहले अपनी जवाब
Yes, lordship. Yes. And they have a. Yes. Was under that act only. Just like banking ombudsman.
That not the redressal of public grievances rules 1998 Lordship. There ombudsman is mentioned.
Okay. 1998. Redressal of public grievance rules 1998 has been superseded by another scheme. Insurance Ombudsman Rules 2017. It is in these books. But redressal of public grievance rules 1998 lagibo. Redressal of public grievance rules 1998 lagibo because we are in 2014 repetition.
No, it is in the same earlier. I have got that in the Insurance Act, my earlier act. Lordship may be taking the new one. The earlier copy, Lordship will find that. Page 183.
No, this is a 2022 edition, so that is not available here.
Yes.
Those are both-
Lordship, I have the 2004. Lordship, it can be.
I can't- Because this repetition is of 2014.
Yes.
So this rule is 2017.
Lordship asked me to look, asked us to look into the judgment. So I've got.
আছে। এখন legal হল redressal of public grievances rules 1998. Do you have a book extra? You can have this for your. Now, what are the facts? Right. Madam, you please read the insurance ombudsman award. Right. Read the insurance ombudsman award so that we can get know of the facts.
Yes, your
I think page 21.
yes, your lordship. This was the first order, your lordship, the page number 21 and Exhibit 6.
Okay.
Yes, your lordship.
Then next.
The second one is on page number 23, your lordship.
Okay, read.
Facts, submissions. The complaint stated that Tata Indica car bearing registration number this belonging to him was insured with the above insurance covering the period from 31 August 2006 to 30 August 2007. During the policy coverage, the vehicle was missing along with driver since 14/10/2006. He informed police on 18/10/2006 as well as the insurer about the loss of the vehicle. The complainant has thereafter lodged a claim for loss of vehicle before the insurer being supported by all the relevant documents, but the insurer has reputed it the claim without any justified ground, feeling aggrieved this complaint was lodged. Now the insurer party also. Shall I read? The insurer has contained in their self-contained note that a passenger carrying commercial vehicle bearing poll number this was issued by them to Mr. Jai Chandra Burman with policy period from 31/8/2006 to 30/8/2007. But the vehicle was registered in the name of Jai Charan Burman. All the documents are signed as Jai Charan Burman. Insurance proposal from form was filed by Jai Chandra Burman on 26/10/2006 when Jai Charan Burman intimated them that his vehicle bearing registration number this was hired on 14/10/2006 and the vehicle was not returned. The intimation was late for 12 days. NFI was lodged with Paltan Bazar PS on 18/10/2006, stating that one person having mobile number this hired the vehicle from Muhammad Alam Hussain, the driver of the vehicle, for one day for going to Nagaon, and the driver was caught and the vehicle was taken by the person who hired the vehicle. The case was registered under Paltan Bazar PS under FIR number this under section 392, 342 IPC, but in it should be FR.
FR.
Final report.
It is noted that Shri Sujit Kumar Saikya, Inspector Paltan Bazar PS, has reported that there is no evidence found that the driver was caught and then the vehicle was stolen. Moreover, it is presumed that Muhammad Alam Hussain, the driver, has stolen the vehicle and shifted to Bihar along with his family. As per the written statement of Mr. Jai Charan Burman, the driver was missing along with the vehicle. They requested the complainants to submit some documents on 17/4/2007 and 22/5/2007. Final reminder was given on 11/7/2007 for submission of the document within 5 days of receipt of the letter. Otherwise, the claim shall be treated as no claim. Ultimately, on 31/7/2007, the claim was closed as no claim for no submission of documents, but the complainant submitted some documents along with his letter dated 7/4/2007. Original registration certificate, original fitness certificate, original permit, letter to detail intimating the loss of the vehicle, having received seal signature, the vital documents to prove the incident of the theft were never submitted. On 26/3/2010, the complainant requested us for reconsideration of the claim without submission of the documents. That is, after 2 years, 7 months, to retract the policy number 7. Finally, the claim was repudiated. Was on the claim on the following grounds: abandonment of the claim as per policy number 7, non-submission of vital documents, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of vehicle, criminal breach of trust by the insurers employed, that is the driver. Hearing, both the parties were called for hearing, on which date the complaint appeared. Personally, insurance were represented by Madhu Chandra Dhar. Their statements were recorded. They were also heard in person. So decision. I have carefully gone through entire documents available on record as well as the statements of the parties. It is an undisputed fact that the vehicle bearing this belonging to the complainant was insured and covered under the above policy. Lodging the complaint for the loss of vehicle on 14/10/2006 due to theft has also not been disputed. The self-contained note of the insurer referred above goes to show that the policy bearing this was issued in the name of Jai Chandra Burman. An insurance proposal form was filled by Jai Chandra Burman, but the vehicle was registered in the name of Jai Chandra Burman. It is presumed that there might be typographical mistake in the middle name of the insured. The first and title were same between first name and title were same between the policy and the registration certificate. Whatever it may be, the the policy in which claim was lost was duly issued by Article branch of insurer. The claim appears to be covered under the said policy. The copy of the letter dated 19/10/2012 issued by the insurer also makes it clear that they have repudiated the claim on following grounds: abandonment of claim as per the policy number 7, non-submission of vital documents, original registration certificate, original fitness certificate, original permit related to detail, intimidating the loss of the vehicle, criminal breach of trust by the insured's employee, that is the driver. It appears from self-contained note as well as from the statement of the representative of the insured that the complainant, Mr. Jayachan Burman, made request for consideration of his claim without submission of the documents on 26/3/2010. That is after 2 years, 7 months, which attracts the policy condition number 7. Insurer has produced copy of the request letter dated 26/3/2010 of the complainant and the terms and conditions of the policy before this authority, which are marked as Annexure J and Annexure L respectively. On perusal of the Annexure J, it is clear that the complainant could not submit all the claim papers before the insurer due to non-receipt of the police final report. On a close perusal of the Annexure L, it is clearly mentioned in policy number 7 of the policy terms and conditions that the company shall disclaim liability to the insurer for any claim hereunder, and such claim shall not be within 12 calendar months from the date of such disclaimer have been made of a suit in a court of law. Then the claim shall for all purpose be deemed to have been abandoned and shall not thereafter be recoverable hereunder. It is ample clear from the above that the complainant made request for consideration of his claim after a gap of more than 2 years from the date of no claim, which is clear violation of policy number 7. The insurer alleged that the complainant has not submitted the original registration certificate, original fitness certificate, original permit to DTO, intimidating the loss of vehicle. It is an admitted fact that the original documents of the vehicle always keep in the vehicle to avoid the security checking or any other administrative purpose. In the instant case also, complainant kept his original documents in the vehicle, for which he lost his original documents along with the vehicle. In that circumstance, the insurer cannot insist the original documents of the vehicle if the insurer produces the certified copies of the documents of the certain authorities. The insurer also alleges that there is a criminal breach of trust by the insurers, that is insured, that is driver. It appears from the copy of SR along with FIR and HD that the complainant informed the police that on 14/10/2006 at 9:30 p.m. one telephone received by his driver Muhammad Alam Hussain from passengers requesting him to go to Nagar, and on the way to Nagar the said passengers caught his driver and then his vehicle was stolen away. On getting HR from the complainant, the police registered a case under case under FIR number this under section 392, 342 IPC. However, it is apparent from the copy of the police final report that during investigation there was no evidence found that driver Muhammad Alam Hussain was caught. The police presumed that the driver Muhammad Alam Hussain had stolen away the vehicle and fled away to Bihar. Finding no clue of the vehicle, they have submitted final report and forwarded to CJM come to Guwahati. On acceptance of the FIR, the complainant has also stated in his statement that on 14/10/2006, the driver Muhammad Alam Hussain took the vehicle with passenger to Nagar, and from there the vehicle was missing along with the driver. It is crystal clear from the copy of police final report that the driver Muhammad Alam Hussain of the insured vehicle of the complainant had stolen away the vehicle bearing registration number. Therefore, it is criminal breach of trust by the insured employer, that is driver. It is proved that there was serious lapse on the part of complainant. Considering the entire facts and circumstances as discussed above, I am viewed that the insurer has rightly repudiated the claim of the complainant, finding no ground to interfere with the decision of insurer, the complaint is dismissed and is treated as closed.
Yes. What is your submission regarding criminal breach of trust?
Uh,
Is there any judgment? Do you have sub?
Yes, Your Lordship.
Which one?
Pardon, Your Lordship.
Mhm.
Uh,
Regarding criminal breach of trust?
Lordship, if we go through the
Okay.
Lordship, section 378 of IPC, illustration D, Your Lordship. Shall I read, Your Lordship?
So that 2008 3 GLT 874.
That no, not from I'm quoting IPC, Your Lordship.
Okay. I see.
No, Ratul Das, I will use that Ratul Das. So with the strength of that, I have tried to establish my case, but Your Lordship.
370.
378 of IPC, illustration D, Your Lordship.
Theft.
Theft, Your Lordship. The theft is defined under 378, Your Lordship. I go through the
Illustration.
illustration
Yes.
D, Your Lordship. A being Z's servant,
Which illustration?
D, Your Lordship.
D.
A shall I? A being Z's servant and entrusted by Z with care of Z's plate, dishonestly runs away with the plate without Z's consent. A has committed theft. And this view was taken by all the precedental laws with the same subject matter. Ratul Das in Supreme Court cases and Ravi
Yeah.
Kant Mishra everywhere this
Which
illustration.
one? Tell me.
So this illustration D, Your Lordship.
The Ratul Das which part?
Lordship, I have submitted a copy with highlighted portions.
Paragraph.
Lordship, kindly come to page number third para.
First paragraph.
Mm.
No, first paragraph perhaps.
In the
Ratul Das. I am looking at Ratul Das.
yes, Your Lordship. If we go to the first one, Your Lordship, the highlighted portion, one need not to prove theft as under criminal
No,
law.
no, let us see the facts first. Okay, the paragraph one is the story. Then which highlighted portion?
Yes.
Okay, one is Ratul Das. Any other?
Yes, Your Lordship. Rest are decided by the, on this point was decided by the
What
National.
case was referred to by the, in Ratul Das, United India
Yes,
Insurance?
Federal Bank versus Sagar
Sagar
Thomas.
Thomas, that is maintainability or litigation.
United India Insurance Limited versus Harchandra Rai Chandan Lal.
Which paragraph it was referred to? Harish Chandra. So that takes care of the allegation regarding criminal breach of trust.
Yes, Your Lordship.
So according to illustration D of sections 378, it is theft.
Yes, Your Lordship.
Now let us see the policy.
I have flag marked it, Your Lordship.
Theft.
It's included, Your Lordship.
Yes, I have to look at it.
The first page, Your Lordship.
Burglary, housekeeping, or theft.
Yes, Your Lordship. May be governed by malicious act also.
Huh?
Malicious, may be governed by malicious act also, Your Lordship. Number 7. The same page.
Theft, it comes under theft.
Yes, Your Lordship.
Definition of theft.
Yes, Your Lordship.
And Ratullah says it is not criminal breach of trust. So that takes care of one part of the
Yes, Your Lordship.
ombudsman's
Yes, Your Lordship.
observation.
Yes, sir.
Then next one is
Non-submission of vital documents.
he has
Yes.
dealt the issue in your favor, perhaps.
Yes, Your Lordship.
1 minute. And what about this clause 7?
Clause 7. Lordship, clause 7
Let us
is
read first.
Lordship. It simply means, Lordship, if no suit has been filed within 1 year after
Read the clause first.
clause, it I have page marked it. It is also hereby furtherly expressed, agreed, and declared that if company shall disclaim liability to the insured for any claim hereunder, and such claim shall not, within 12 calendar months from the date of such disclaimer, have been made the subject matter of a suit in a court of law, then the claim shall, for all purposes, be deemed to have been abandoned and shall not thereafter be recoverable hereunder.
So what does it mean?
If no suit has been filed within
No,
1 year,
first condition, what? First condition. If the company shall disclaim the liability to the insured for any claim hereunder. Let us see on which date it was repudiated.
on 19th October 2012.
No.
19th October
2012.
Yes, 19 October 2012. Okay. This is the repudiation
Yes.
as per clause 7.
Yes.
Then next is such claim
Such
shall not.
within 12 calendar months from the date of such disclaimer have been made a subject matter of a suit in a court of law.
Second that
Yes.
if no suit is filed
Within 12,
within 12 calendar months, then
then
the claim shall all for all purposes be deemed to have been abandoned
and
and shall not thereafter be recoverable thereafter.
This is ultra virus.
So, you have filed this repudiation in 2014.
I have filed in 2014, Your Lordship. But we went to the insurance ombudsman in 2013. 12, sorry. We went to the insurance ombudsman in 2012, Your Lordship. Furthermore, Your Lordship, this cause of action governs under the 1997. On the last occasion, Your Lordship had enlightened me to go to the Law Commission that had amended the Section 28 of Indian Contract Act, Section 28B. So in that case, this case shall govern under that because the exclusion clause of 3 shall not include in my case because I came in 2014 here, but my reputation was done in 2012 and I went to insurance ombudsman within 1 year of that is in 2012 itself.
Have you read exception 3?
Yes, Your Lordship. That
Yes.
was after that was in effect from January 2013. That came into effect on January 2013. Yes, Your Lordship. I did my homework.
You did your homework.
On 18 with effect from 18 January 2013, this exclusion clause 3 was
That was
included.
by Banking Laws Amendment Act 2012.
Pardon,
So it affects from
18/1/2013. This exclusion clause 3 came into effect. But Your Lordship,
yes 18. And secondly, anyway, in any way of the matter, that exception 3, then there are some expression bank. Does this insurance company falls under expression bank?
no,
No.
it does not come under
Okay.
that.
Then financial institution clause Roman 2.
I think it does come under.
Roman 2 in exception 3. The expression a financial institution means any public financial institution within the meaning of section 4A of the Companies Act. Any idea? Okay. Yes, MS Mojumdar.
And
Lordship has started what I would have said. Lordship, thing is correctly, Lordship said, because first when it was first amended, then this thing was, everything was in it. Then I think the banks and financial institutions.
As MS Das has pointed out,
Yes,
this exception 3
yes.
has been inserted
Hmm.
only with effect from 18/1/2013.
That apart, Lordship, because her
Your
claim was-
information, just I'm putting
Yes.
you across, then you answer.
Yes, Lordship.
That exception 3, your reputation was on 19/10/2012.
No. No
Come.
claim, Lordship, was intimated on 31/7/2007 itself. Thereafter, he
That is closed.
no claim.
That is closed.
Thereafter, Lordship will Lordship, I would like to take Lordship to the first order of Ombudsman. First order of Ombudsman, Lordship, he did not disclose there that his claim was, because as per section 7 also, disclaim liability that is there.
Address on clause 7 first.
On clause 7, that's what, Lordship. Clause 7, the time will be from 2007, because that was the time when his claim was disclaimed. It is mentioned in the Ombudsman judgment also.
What does clause 7 says?
Clause 7 says, if I read the whole or the last part, it is also hereby further expressly agreed and declared that if the company shall disclaim liability, this is important, to the insured for any claim hereunder, and such claim shall not, within 12 calendar months from the date of such disclaimer have been made the subject matter of a suit in a court of law, then the claim shall for all purposes be deemed to have been abandoned and shall not thereafter be recoverable hereunder. So the vital points here, Lordship, that disclaim liability, if it is not within 12, a suit is not filed, Lordship. And it is to
Suit
be.
means any application, before any forum, adjudicatory forum. Because he has interpreted, because Ombudsman has interpreted that within 1 year it was not filed.
In this case, it was not filed. But they are not challenging the Ombudsman judgment, Lordship. In this writ petition, they are not challenging the Ombudsman judgment. What their prayer is, Lordship, is that on the premises above, it is prayed that your Lordship would be pleased to call for the consent document issue rule, call upon the respondents to show cause as to why payment of the claim made against insurance policy number so and so on dated 31/08/2007. This is the date, Lordship, should not be made hearing the parties perusing the documents. It is prayed that your Lordship would be pleased to issue a writ of mandamus, certiorari, or any other writ direction of like nature, and or pass such orders upon the respondents to materialize the petitioner's claim against the insurance
In
policy.
substance, they want the claim allowed.
Yes. They are not challenging the Ombudsman judgment in any manner. Lordship, I have submitted one judgment, Sadhana Lordship, when they have alternative, because they are governed by the Consumer Act. The petitioner is a consumer against under the their relation is, contract is as consumer, insured and insurer. So they are governed by the Consumer Protection Act. Writ petition is not maintainable. Totally not maintainable. And
Does Southern law says?
Sadhana Lord.
খুলি দিছিলো যে। খুলি দিয়ে Southern law.
নাই যদি মই দিব পাৰিম আৰু এখন।
Take out. Which paragraph?
Lordship, the relevant paragraph will be paragraph 6, 7, Lordship. The supervisory jurisdiction conferred on the High Court under Article 227 of the Constitution is confined only to see whether an inferior court or tribunal has proceeded within its parameter and not to correct an error apparent on the face of record, much lesser an error of law. In exercising the supervisory power under Article 227 of the Constitution, the High Court does not act as an appellate court or the tribunal. It is also not permissible to a high court on a petition filed under Article 227 of the Constitution to review or revoke the evidence upon which the inferior court or tribunal purported to have passed the order or to correct error of laws in the decision. 7. For the aforesaid reason, we are of the view that since the insurer had a remedy by filing an appeal before the High Court ought not to have entertained the petition under Article 226 to 27 of the Constitution.
This is alternative remedy in that context.
Yes, Lordship,
The
what happened?
statutory appeal was available, but insurance company
They
tried to
filed-
avail remedy under 227 or 226.
Yes, because under the Motor Vehicle Act, under Section 173, insurance can go for.
Where the statutory provision against an order of ombudsman.
They have not
You-
filed. That is why
No.
they have not
Mr.
filed.
Junda.
Yes, Lord.
This judgment was rendered in the context of availability of an option to file appeal under Section 173 Motor Vehicles Act 1988.
Yes.
This judgment has been rendered, Sadhana Lord, that insurance should avail the remedy under MVL, not through a writ petition or 227 petition. Now, otherwise, tell me whether writ petition is barred.
Lordship, if we go by, I have given other judgments also, Lordship, where those were related to insurance policy itself, and where the apex court said that though in that particular case, though it was allowed, but the
ASA.
Asha Goel.
ASA is referred, ASA is maintainable in some situation.
Some situation. But Lordship, what is the special situation here?
Yes.
If there is fraud or yeah. And Lordship, they are in fact, Lordship, if we go by the
This misconception about criminal breach of trust is an error, manifest error in interpreting a provision of law.
Lordship, that's what I'm
Appears to be.
that is why I'm submitting, Lordship. They have not challenged the ombudsman judgment. They have not challenged. What they are praying before Lordship is that Lordship will direct us to pay the amount to them, Lordship. When Lordship, this
What is the scheme? Ombudsman scheme.
ombudsman, Lordship.
It is framed by insurance companies only.
Lordship, this section 3, Lordship, I have.
2017 নালাগে পুৰণিখন
মোৰ কিতাপখনত আছে। 5, 6, 7, 8. Lordship, I found that in fact their complaint before ombudsman was also not maintainable. Thirteen three. Three. No complaint to the ombudsman shall lie unless. A. The complainants had, before making a complaint to the ombudsman, made a written representation to the insurer named in the complaint, and either insurer had rejected the complaint or the complainant had not received any reply within a period of 1 month after the insurer concerned received his representation, or the complainant is not satisfied with the reply given to him by the insurer. In our case, Lordship,
in your case, this
Reputation
when
was-
they filed a complaint,
Lordship, reputation
they
was.
filed complaint that was
Lordship, in on 31/7/2007, the repudiation was made, no claim was declared. Then he made a request for
Because,
reconsideration on
one thing,
26/3/11.
MS Mojumdar,
Then, yes, sir.
come to page 23.
23 of their,
And it just
See how the complaint was registered. Complaint case was of 2011 and 2012.
Hmm.
That man came again.
that's why I'm giving the dates, Lordship. That why the dates are important. Lordship, his no claim was intimated to him on 31/7/2007. Then he made a request for reconsideration by his letter dated 26/3/2010. And he filed the first complaint on 8/4/2011. And the second complaint was filed on 10/12/2012. And judgment by ombudsman was passed on 31/1/2013.
13. In 2013.
Yes. No, first petition, yes. 2013.
First one was to consider,
Yes.
is it not?
Yes,
Yes,
because
Your
their lordship, he did not
See,
reveal.
January 13, 2012, the first order was passed.
Hmm.
Right?
Hmm.
Insurer shall complete the process of settlement of the claim. You appeared before the
No.
ombudsman?
It was ex parte. He did not inform that what he presented. That's why I'll read this order first, Lordship. Because Lordship, here he did not inform that his case was already it was rejected. It was his no claim was intimated to him on in 2007 itself. So ombudsman did not know that there it was a no claim case. He submitted that, Lordship, the decision, para 3, page 22.
Oh, where is your intimation that you have closed?
That was given to him, Lordship. And those
Show
were,
me.
no, those were given in the
Where? How?
ombudsman, Lordship. It is mentioned in the judgment also.
No,
Ombudsman
giving
judgment.
information to the ombudsman does not amount to giving information to the insured. Where you have closed. Closed means what? Non-submission of documents.
Hmm.
That is your statement in your affidavit. Is it not?
Yes.
Then he made an application.
Yes.
You have reconsidered.
On 26/3/2000. No.
Then?
We did not reconsider. There was no reconsider. Only after the again.
Madam, then why you have made a statement before the ombudsman that you repudiated the claim
Yes, it was repudiated.
on 19/10/2012? Come to page 26. Fifth line. The copy of the letter 19/10/2012 issued by the insurer also makes it clear that they have repudiated the claim on the following grounds.
Yes, because Lordship, the repudiation was made on 31/7/2007 itself. And by that letter.
Madam, 31/7/2007, clause 7 cannot come into picture.
31
Madam, clause 7 cannot come into picture. By no stretch it can come into picture. And plus, final report was submitted in 2010.
Yes.
That clause cannot come into picture.
final
This
report.
criminal breach of trust scenario you have brought, that cannot come into picture.
Lordship, breach of trust.
You cannot, on your own, when the final report was not submitted, cannot reach an opinion that criminal breach of trust. Because IO has submitted the final report in 2010. Is it not?
Yes, Lord. I have a copy.
Very good. That is why I asked.
Yes, I have a copy along with the date they received our final report, 25 March 2010.
25.
How can you in 2007 close the case
Because
as criminal breach of trust?
No,
You
no,
are
that
an investigator.
No, that was
Madam.
Lordship abandonment. That was because they did
Then
not.
you considered when he approached again, you considered and repudiated the claim. On 3 grounds this time. Earlier,
It was
you say
no claim.
closed, no
Claim.
submission of document,
No claim. It was, yes.
right?
Hmm.
You could not have reached the ground of criminal breach of trust in 2007.
No, no,
Am
no.
I clear?
That,
These 3 grounds you have taken in the on 12/9/2012. Ombudsman has recorded 3 grounds you have taken for repudiation of claims.
Hmm.
Ombudsman considered all 3 grounds.
Hmm.
1 ground has gone in his favor. 2 grounds had gone against the institute. Right? One is clause 7,
Hmm.
and other is criminal breach of trust.
Hmm.
I think that is the proper sequence of events.
yes, yes.
Anything on clause 7? Are you financial institution?
Yes, Lord. Yes,
In terms of exception 3 clause sub
yes,
clause
yes.
Roman 2.
Yes.
Read.
Lordship Companies Act 2013. Public financial institution means life insurance company, infrastructure development. I'm just short cutting, Lordship. Specified company referred to in the Unit Trust of India, an institution notified by central government under subsection 2 of section 4A of Companies Act. I think ours will be in this category. No. Okay.
No.
Such other institutions
Even
as maybe.
one see
Lordship, I got a judgment on that. What Lordship
one thing, this exception 3 has been inserted only with effect from
18 January 2013.
your reputation was
19
much earlier.
2010.
By exception 3, one exception has been carved out. That is with effect from 2013. Prior to that, it was not there. Simply section 1 and 2. Right.
So that gives 3 years. That is what Lordship is saying.
No,
It will be
this
governed by
clause,
limitation act.
this
then.
clause is void.
No, that it will be
If
by
you
limitation act.
employ, you take recourse to clause 7, this clause is void. That clause itself is void, illegal.
No, then the time will be Lordship is saying as per limitation act 3 years.
If you have that ombudsman had repudiated the claim on the ground of clause 7.
Hmm.
Right?
But they're not challenging the ombudsman.
Not
Lordship.
required. When two entities enter into an agreement,
Hmm.
Law Commission has said one having more bargaining power, the other having lesser bargaining power. Because of that, this situation arises. And that has been interpreted by many judgments. And even on a reading of the clause itself, that is void to that extent. That clause is void to that extent. You have limited the insured that don't go. If you don't go within a period of 1 year, then you cannot go thereafter. That is the case. To the court of law. Read again section 28.
Section 20.
What is the clear meaning there?
I read it again and again.
You read and read. I've been reading it and reading it.
28. Agreement in restraint of legal proceedings void.
Void. Simple.
Every agreement.
Hmm.
By which any party thereto is restricted absolutely from enforcing his right under or in respect of
Or in respect of any contract,
Contract.
or by the usual legal proceeding in the ordinary tribunal, right?
Hmm.
This is one part.
Hmm.
Suppose by agreement, Mr. M.S. Mojumdar says that Ms. Das, you cannot
within 1 year.
approach a court of law. Void.
If not 12 months.
No.
That
One part. There are 2 parts.
Hmm.
First part, every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceeding in the ordinary tribunal. Right? That is one part. Next part, or which limits the time within which he does enforce his right.
12
This
months.
part,
The 12
you
calendar
have
months.
limited the time to MS Das that within 1 year, if you don't approach, you are barred from enforcing your right under this contract. What is the line? Last is void to that extent. One is completely or absolutely barring MS Das to approach the court. The next one is
Limiting the time.
limiting the time. Bringing the Limitation Act out of the purview.
So that means
That is void. Now, exception 3. Exception 3 is carved out because of bank guarantees,
Hmm.
not insurance policy, madam.
But then, Lordship, this word that financial institution.
I
So-
examine. You do not fall. LIC falls.
LIC is there. Yeah.
LIC falls.
But then, Lordship, again,
Firstly,
Lordship,
in exception 3, the exception bank means, right?
Hmm.
A, B, C, D, E, F, G.
banking
You do not
company,
fall.
correspondent new bank, State Bank of India, subsidiary bank. But
One.
just for my personal Lordship, what I find is if some bank is not mentioned here, I'm just talking about bank, so they won't be giving
No, no.
even this exception.
A, banking company as defined in clause so and so, that has been interpreted and that has been amended.
So then,
Cooperative bank also.
then why they are naming State Bank, especially State Bank?
Because
And
it is State Bank is under an act.
that's why they are mentioning.
Punjab National Bank is not under an bank.
That's
Act.
what. That's what. Okay.
Okay. We'll proceed.
And then, Lordship, so the date comes, Ombudsman judgment came on 3/9/2013.
Sadhana Road and other.
And Goel, I had given Lordship.
Asa Goel.
Yes, Lordship. Asha Goel, the Apex Court in that case, life insurance case was there. The Apex Court said that in this particular, Mr. Harish Salve argued and he said, "Ki Lordship, we will give the judgment, we give the amount, but then Lordship will make it clear that when there is a provision to file a case under the Consumer Act, can writ petitions be filed?" So Apex Court made that clear.
Constitution bench has made it clear in L. Chandra Kumar. Nothing is required. Anyway, which paragraph? Asa Goel, Asa Goel. Asa Goel.
Since Lordship is going to reject it, so
Asa Goel. Yes, paragraph 10 perhaps.
I'm getting my. Yes. Paragraph 10, last part, Lordship. Whether a writ petitioner is merely attempting to enforce his her contractual right or the case raises important questions of law and constitutional issues, the nature of the dispute raised, the nature of inquiry necessary for determination of the dispute, the matter is to be considered in the facts and circumstances of each case. While the jurisdiction of the High Court to entertain a writ petition under Article 226 of the Constitution cannot be denied altogether, courts must bear in mind the self-imposed restraint consistently followed by High Courts of all these years after the constitutional power came into existence in not entertaining writ petitions filed for enforcement of purely contractual rights and obligations which involve disputed questions of fact. The court have consistently taken the view that in a case where for determination of the dispute raised, it is necessary to inquire into facts for determination of which it may become necessary to record oral evidence of proceeding under Article 2 to 6 of the Constitution is not the appropriate forum. The position is also well settled that if the contract entered between the parties provide an alternate forum of resolution of disputes, arising from the contract, then the parties should approach the forum agreed by them, and the High Court in writ jurisdiction should not permit them to bypass the agreed forum of dispute resolution. So that is the Lordship. And in our High Court itself, Lordship, a similar type of case was there. Then another bench, Lordship, it was allowed, though the limitation time was gone, allowed, though the limitation time was over, like, so allowed the petitioner to approach the consumer forum.
Here is a question of misreading a provision of law. This clause 7, he has completely misread.
No, they are, that
And
is
over and above that, insurance companies' reliance on clause 7 is completely contrary to section 28 of the contract.
Hmm.
And that clause is void to that extent. Have you understood
I understood.
what I am
I understood
saying?
last night only.
Firstly, insurance ombudsman relied on clause 7 and misread clause 7. First thing.
Because
Second
maybe
thing,
they did not relate it with the
but
other.
the reliance on clause 7 is contrary because clause 7 itself is void. Because you have limited the time
Correct.
that don't go to the court after 1. That itself is void. And repudiation of the claim on the basis of clause 7 is also bad in law. It appears mala fide on the part of the insurance.
No, Lordship, I wouldn't say melified.
I'll not record that.
Lordship, it is not
This is
melified.
completely-
It is
this
their
is a
understanding.
clause why the history has been traversed by Law Commission of India many times and found that bargaining power and standard form of contract everywhere, this party having higher bargaining power puts such kind of clause.
No, that's with every negotiation, Lordship. That is with
On
every kind
equal
of.
footing is a different thing.
No, Lordship. When we go to
State
hire, suppose dhania, Lordship, to the market, because I am the buyer, I always
Don't,
it
Miss
is negotiation like
Mazumdar,
that only, Lordship.
don't compare insurance, Oriental Insurance Company versus a Tata Indica owner with a Dhunia vendor versus you.
No, Lordship, I'm saying about negotiation. That where it is not a question of it is not melified. That's what I would submit,
Is
Lordship.
it not a standard form of contract?
It is. In fact, the other
So there
judgment.
is no question of bargaining here.
Lordship, with every customer, with every vehicle,
You are having a team of legal
lawyers,
experts.
yes,
Still, you put this clause,
yes.
which is completely contrary to
That-
section 28.
That I agree. That I agree, because some.
I am not putting that thing to you.
Oh, thank you, Lordship, because I don't want that should be melified, Lordship. But I did a good exercise, Lordship, in
Yes.
this, because even I learned that section 28, about section 28, I didn't know, even though I'm doing insurance cases, I didn't know, and I have to give a writing on that to them, because they have to change this.
The instant writ petition is preferred. Instant petition under Article 226 of the Constitution of India is preferred. Seeking preferred seeking interior direction to the respondent insurance company to satisfy the claim in respect of an insurance policy which the petitioner as the insured had taken from it in respect of a vehicle. Full stop. The petitioner has approached this court after the insurance ombudsman, Guwahati Center, had rejected a complaint preferred by the petitioner as the complainant before it, by an order dated 3/9/2020. Rejected. Yeah. The relevant facts or relevant events which led the petitioner to prefer the petition can be narrated in brief as follows. Sub. The petitioner purchased a four-wheeler vehicle within bracket Tata Indica car in the year 2006 with financial assistance from Messrs. HDFC Bank. Full stop. After the vehicle having is 11 chassis number so and so and engine number so and so had been registered with the district transport officer within bracket registration and licensing Kamrup Guwahati with registration number AS01 AA-5744. The petitioner was flying the subject vehicle. The petitioner was flying the subject vehicle as a commercial vehicle after obtaining permit from the district transport officer, registration and licensing Kamrup. For the period from that period here somewhere. After obtaining tourist cab permit with validity up to with validity with effect from 13/9/2006 to 5/9/2011. Full stop. The subject vehicle was also insured under a package policy within bracket passenger carrying commercial vehicle for four-wheel carrying. Bearing number, where is it? Page 14, insurance policy number. Any idea?
Number 321150
Where it is found, can be found?
Page 4 of writ petition, para 4.
and your
Okay,
lordship,
page 4.
page number 25 also.
Okay. Page 4. Paragraph 4. For the period from 31/8/2006 to 30/8/2007. The further case of the petitioner was that on 14/10/2006, the subject vehicle was hired by some passengers after by contacting the driver for the purpose of for traveling to Nagaon from Guwahati. Full stop. According to the petitioner, the driver engaged by the petitioner, Mohammed Alam Hussain,
Yes, your lordship.
Alam Hussain, after informing the petitioner that he was taking passengers to Nagaon, proceeded to Nagaon. Full stop. When the petitioner did not receive any information about the subject vehicle as well as the driver, despite searches, he had lost the first information report before the Paltan Bazaar police station on 18/10/2006.
Yes, lordship.
Full stop. The petitioner had also stated that the matter was also informed to the insurer immediately. Will come to it. His averment will come recorded it. The FIR was registered as Paltan Bazaar Police Station, case number 596/2006 for the offences under sections 392/342, Indian Penal Code. After the matter was informed to the insurer, the petitioner was asked to submit certain documents. Full stop. The petitioner has stated that there was some delay on his part to submit those documents, as all documents were inside the subject vehicle at the time it was hired on 14/10/2006. Full stop. As the documents like registration, certificate of registration, fitness certificate, permit, etc. in original were inside the subject vehicle, the petitioner had obtained duplicate copies of those documents from the concerned authorities in order to submit the same before the insurer. And in the process, some delay occurred in submission of those documents. Full stop. When, according to the petitioner, when repeated approaches did not result in any, did not result in satisfaction of the claim by the insurer, he has submitted a representation on 4/8/2010. Thereafter, he had approached the Insurance Ombudsman Guwahati Center on 8/4/2010 by submitting a complaint. The complaint was admitted by the Insurance Ombudsman under Rule 12 within bracket 1 within bracket small e of the redressal of Public Grievances Rules, 1998. Full stop. After consideration, the Insurance Ombudsman dispose of the complaint by an award dated 13/1/2012, observing that the insurer shall complete the process of settlement of the claim within 15 days from the date of receipt of the letter of acceptance of the award from the complaint. Madam, please take your seat. The after the award of the award dated award dated 13/1/2012, the petitioner was asked to submit when the petitioner made another representation, sorry. When the petitioner, the insurer did not proceed to satisfy the claim under the insurance policy, the petitioner had to approach the insurance ombudsman again by submitting a complaint on 10/12/2012. Facts are correct?
So in between that, when the first order was of ombudsman came, then petitioner served a copy of the ombudsman order to the insurer. That is on dated 9th February 2012. Thereafter, the second order came. That is annexure number 6, maybe. No, not 6. The date is 9.
Not there. Which is not there, I cannot now. Which is not there on paper, I cannot record, whatever is available. On 10/12/2012. The said representation was registered by the insurance ombudsman as complaint number 14-04-067 stroke 11-12 under rule 12 within bracket 1 within bracket small b of the redressal of public grievances rules 1998. Before the insurance ombudsman comma both the sides after appearance comma projected their case with the on the basis of documents in support of their respective contentions. Most of the matter was considered by the insurance ombudsman and by an award dated 3/9/2013, comma sorry, during the course of the proceedings before the insurance ombudsman, comma, it was it had emerged that the insurer had repudiated the claim of the petitioner by a letter dated 19/10/2012 on a number of grounds. Full stop. After consideration of the matter, including the grounds on which the claim of the petitioner were repudiated, comma, the insurance ombudsman by his award dated 3/9/2013 had observed that the insurer had rightly repudiated the claim of the complainant within bracket the petitioner, petition. Full stop. With such observation, comma, the complaint preferred by the petitioner hearing was dismissed. Full stop. Hence, the repetition. I have heard MS
PDAS, your lordship.
PDAS, Learned Counsel for the petitioner, and MS RD Mojumdar, Learned Counsel for the sole respondent dash insurer. Full stop. MS Das, Learned Counsel for the petitioner, has submitted that the claim of the petitioner was repudiated by the insurer on 3 counts. Full stop. Has submitted. It has been contended that none of the three, sorry, on citing 3 grounds. Full stop. Out of the 3 grounds, comma, the insurance ombudsman had accepted, had recorded its findings in the insurance ombudsman had recorded its finding in favor of the insurer in respect of 2 grounds, while recording its finding in favor of the petitioner as regards non-submission of vital documents like original registration certificate, original fitness certificate, etc. Full stop. MS Das has contended that the repudiation of a claim on the ground that there was commission of criminal breach of trust by the insured, or the petitioner's, sorry, the driver of the subject vehicle is not sustainable. Full stop. The police had reported, police had after completing its investigation, submitted its final report on
Final report. 23,
no, but not the 23, madam.
in the final report.
On 7/9, sorry, not 7.
No, it's on 23/8. 23. 7/9 magistrate accepted.
Final report which stood forwarded to the jurisdictional magistrate on 23/2009, and the jurisdictional magistrate that is the chief judicial magistrate within bracket chief judicial magistrate Kamrup Guwahati had accepted the final report while it is ordered dated 7/9/2009. So thereafter, the petitioner had deposited, had submitted the said final report along with the original keys, original policy, insurance policy, etc. to the insurer company. Full stop. By referring to the definition of theft provided by section 378 Indian Penal Code and illustration small d bracket of it thereof. MS Das has contended that the case, the claim of the petitioner could not have been repudiated on the ground, on the alleged ground of commission of criminal breach of trust by the driver of the subject vehicle. By referring to the insurance policy, clauses, terms and conditions of the insurance policy, it has been contended that quote unquote theft was an incident of theft was covered under the insurance policy. So since the instant case, since the case in hand was an act of theft, the repudiation of the claim on the petitioner was clearly arbitrary and illegal. Full stop. MS, it is further contended that clause both the insurer and the insurance ombudsman had referred to policy condition number 7 to reject the claim of the petitioner. Full stop. It is the contention that condition number 7 has been clearly misread by both the insurer and the insurance ombudsman. Full stop. By the policy condition number 7 in the insurance policy, an insurer was the said policy condition number 7 is clearly contrary to the provision contained in section 28 of the Indian Contract Act 1872. Full stop. তার আগতে লিখিব, MS Das has also relied in support of her contention. MS Das has relied upon a judgment of a division bench of this court in Ratul Das versus Oriental Insurance Company Limited and others, reported in 2008-3 ZLT 874. All contrary. MS Mojumdar. counsel appearing for the respondent insurer has supported, has contended that the claim of the petitioner was rightly repudiated by the insurer. Full stop. She has further contended that all the three grounds for repudiation were valid and no interference is called for. Full stop. The findings recorded by the insurance ombudsman as regards the policy condition number 7, policy condition number 7, and criminal breach of trust by the driver of the subject vehicle yes contained findings recorded where are where which regions and such regions are not required to be interfered with in a read proceeding preferred under Article 226 of the Constitution. Full stop. In support of such, to buttress such submissions, reference has been made to the decision of the Honorable Supreme Court of India in Life Insurance Corporation of India and others versus Asa Goel Srimoti and another reported in 2001, 2 SCC 160 and both load Sadhana.
2003
Sadhana load versus National Insurance Company Limited and another reported in 2003 SCC 520. I have duly considered the submissions of land. Anything more?
No.
I have duly considered the submissions of land council for the parties. I have also gone through the
only thing like that they have that alternative remedy before consumer court.
also, as Modunda has further submitted that the petitioner had alternative remedy before the district forum, district consumer forum. And as such, this writ petition is not maintainable. I have also gone through the materials brought on record by the parties to their pleadings. First of all, Land Council for the parties have placed a copy of the commercial vehicles package policy within bracket marked as X. There is no doubt about it,
No.
comma, by which the subject vehicle of the subject vehicle was insured. Yeah. As a question regarding maintainability of a writ petition under Article 26 of the Constitution of India. Has been raised, it is opposite to advert to the only education. Man, what lagi itu kan? Asal betul. Kartu saran lo. The matter of enforcement of claim under a contract of insurance, where the insurance had repudiated the claim, has been considered by the Honorable Supreme Court of India in Asagoel Supra. Having regard to the power of judicial review available to the High Courts under Article 226 of the Constitution of India, the Honorable Supreme Court of India has observed as under para 11. Para 11. Huh? Para 2, para 11. Just resume after 14. The appellant therein filed a claim application before the Motor Accident Claims Tribunal seeking compensation for the death of the appellant's son in a motor vehicle accident. Full stop. The learned tribunal awarded a sum of rupees 3,50,000 as compensation. Full stop. Agreed by the. It is called award, right? Award. Agreed thereby, the insurer. That is National Insurance Company Limited. Filed a writ petition under Article 226 and Article 227 of the Constitution of India before this High Court. First of a learned single judge of the High Court dismissed the writ petition. Full stop. The insurer carried the matter to the division bench by way of a letters patent appeal. Full stop. Before the division bench, the appellant claimant took an objection that a petition, writ petition under Articles 226 to 227 would not be maintainable. And as such, the latest patent appeal should reserve dismissal. When the division bench of the High Court allowed the appeal preferred by the insurer and reduced the compensation from 3,50,000 to 3 lakh, the special leave petition was preferred by the appellant. Full stop. By granting the leave, the Honorable Supreme Court had observed as under Para 6. And 7. The insurance ombudsman was constituted under the Redressal of Public Grievances Rules, 1998, within bracket since repeal, framed by the central government in exercise of the powers conferred by subsection 1 of section 114 of the Insurance Act 1938. Section 6 of the Rule 6 of the state rules RPZ rules কৰি দিব for short. Provided for appointment of ombudsmen. Full stop. Rule 12 of the RPZ rules had outlined the powers of the ombudsman. Full stop. As per clause B of Rule 12, the ombudsman could receive and consider any dispute in regard to any partial or total repudiation of claims by an insurer. Full stop. On the other hand, Rule Clause E of Rule 12 permitted an ombudsman to receive and consider a matter involving delay in settlement of claims. Full stop. Rule 13 provided for the manner in which a complaint was to be made, and Rule 16 had provided for an award by the ombudsman. Full stop. According to Rule 7, which provided for consequences of non-acceptance of award, if the complainant did not intimate the acceptance under sub-rule 5, did not intimate the acceptance, the award passed by the ombudsman could not be implemented by the insurer. The RPG rules 1998 did not specifically provided for did not specifically provide any remedy by way of an appeal. Full stop. Did not specifically provide for any appeal. Had neither specifically provided for any statutory appeal against any award of insurance ombudsman, nor had mentioned that a complainant, if aggrieved, nor had specifically mentioned that if a complainant aggrieved by an award passed by the insurance ombudsman, should approach the district consumer forums constituted under the Consumer Forum Act,
Consumer Protection Act.
Consumer Protection Act 1985, 86, as amended. Full stop. None of the decision, full stop. The decision in Sadhana Loan was rendered in the context that a specific statutory right of appeal was available to the insurer under Section 173 of the Motor Vehicles Act 1888. In Asa Goel Supra, it has been observed that it cannot be laid down as a general proposition of law that in no case the High Court can entertain a writ petition under Article 226 of the Constitution of India to enforce a claim under a life insurance policy. Full stop. Like a life insurance policy, comma, the insurance policy involved in the case in hand is also a contract entered into between the petitioner hearing as the insured and the respondent hearing as the insurer. Full stop. It is settled that rule of exclusion of not entering a writ petition is a matter of policy, convenience, and not a rule of law. So it is tried to say that ordinarily a writ petition filed for enforcement of purely contractual rights and obligations involving disputed questions of fact, comma, is not entertained. Is not to be entertained. Full stop. It has been held consistently that in a case where for determination of dispute raised, comma, it is necessary to inquire into facts for determination of which it may become necessary to record oral evidence. A proceeding under Article 226 of the Constitution of India is not the appropriate forum. Full stop. Keeping the aforesaid proposition in mind, it requires to look into the facts and circumstances situation involved obtaining in the case in hand as to whether the instant repetition is required to be entertained, should be entertained or not. the facts that the petitioner was a registered owner. Registered owner
Yes, your lordship.
of the subject vehicle, and the subject vehicle was under coverage of an insurance policy within bracket commercial vehicles package policy. During the period from 31/8/2006 to 38/2007 were not in dispute. Full stop. The incident which led the petitioner to lodge the claim under the insurance policy occurred on 14/10/2006. Full stop. In the FIR registered as Polton Bazaar Police Station, case number
596.
596/2006, lodged on 18/10/2006, the petitioner as the informant had alleged that on 14/10/2006, the subject vehicle was hired by some passenger after negotiating the matter of hiring with the driver of the subject vehicle, Mohammed Alam Hussein. Full stop. After negotiation, the matter was duly informed by the driver of the subject vehicle to the petitioner. Full stop. When neither the vehicle, when no trace was found of either the vehicle or the driver, subject vehicle or the driver, the petitioner had lodged the FIR on 18/10/2006. From the materials on record, as well as from the award of the insurance ombudsman dated 3/9/2013, it is noticed that the investigating officer of Polton Police Station, case number 596/2006, submitted a final report in that case by reporting that there was no evidence was found that The driver of the subject vehicle was caught. Full stop. It was presumed that driver of the subject vehicle had stolen away the vehicle and fled away to Bihar, his native place. Full stop. From the copy of the final report placed before this court, it is found that the investigating officer of the case had reported that the case under section 381 IPC was true. Full stop. As the investigation officer had further reported that as there was no trace of the accused, the final report was filed. Full stop. The final report was thereafter forwarded by the officer in charge, Paltra Police Station, to the jurisdictional magistrate, to the court of learned chief judicial magistrate, Kamrup Metro, to the PI, Guwahati Court, on 23/8/2019. Full stop. The final report was came to be accepted by the learned chief judicial magistrate, Kamrup Metro, on 7/9/2009. After hearing the complainant, that is the petitioner, had when the petitioner approached the insurance ombudsman for the first time, complaining that the insurer had not taken any steps to settle the claim. The said complaint was registered as complaint number page 21 14-005-043/11-12 under rule 12(1)(e) of the RPG rules. After going through the documents on record, the insurance ombudsman had observed that the claim of the complainant claim for settlement. Claim for settlement was pending with the insurer for a long time. Full stop. Observing so, the insurance ombudsman passed an award on 13/1/2012. Observing that the insurer shall complete the process of settlement of claim within 15 days from the date of receipt of the letter of acceptance of the award from the complainant. It was further observed that if the claim was found payable, the insurer shall pay penal interest at 8% per annum on the settled amount with effect from the date of submission of the claim papers till the date on which the settled amount was released. Para. The petitioner had approached the insurance ombudsman for the second occasion after repudiation of the claim on the ground that the claim was repudiated without any justified grounds. Full stop. The complaint referred by the petitioner was registered as complaint number page 23 under Rule 12(1)(b) of the RPG rules. Full stop. The insurance ombudsman had found that the claim of the petitioner was repudiated by the insurer by letter dated 19/10/2012 on three grounds. One, abandonment of the claim as per the policy condition number 7, page 26 of the non-submission of vital documents, original registration certificate, original fitness certificate, original permit, letter to DTO intimating the loss of the vehicle. Next, criminal breach of trust by the insured employees, that is a driver. The stand taken by the insurer in the affidavit in opposition is to the effect that on 31/7, after receipt of information from the petitioner, the petitioner was requested to submit relevant documents on 17/4/2007 and 22/5/2007. Correct? Your affidavit. Full stop. Thereafter, a final reminder for submission of document was given on 11/7/2007 to the petitioner. with the observation that in the event of failure, comma, the claim would be treated as no claim. Full stop. The claim was ultimately closed on 31/7/2007 as no claim due to non-submission of documents. Full stop. Thereafter, comma, it was on 26/3/2010, comma, the petitioner approached the insurer with a request to reconsider his claim. And after examining the same, comma, the claim was repudiated on the three grounds, comma, mentioned already mentioned here in a para. As regards non-submission of documents by the petitioner before the insurer, and as regards the ground regarding non-submission of documents by the petitioner in support of his claim, comma, the insurance ombudsman had observed that ordinarily, comma, the original documents of a vehicle were kept inside the vehicle to avoid security checking or any other administrative purposes. Full stop. In the case of the petitioner, the insurance ombudsman had further observed that in the case of the petitioner, comma, the original documents were kept inside the subject vehicle, for which he lost his original documents along with the vehicle. Full stop. In such, it was thus observed that it was in such circumstances, comma, the insurer could not insist for the original documents of the subject vehicle. Could not have insisted for the original documents of the subject vehicle if the petitioner had produced the certified copies of the required documents from the concerned authorities. The insurance ombudsman had accepted the ground on which the insurer had repudiated, accepted the ground that there was commission of criminal breach of trust by the driver of the subject vehicle. comma, one of the grounds on which the insurer had reported the claim. Full stop. To reach a view, to reach such a view, comma, the insurance ombudsman had referred to the final report submitted in connection with Baltimore Police Station case number 596/2000. Full stop. In the final report, comma, the IO had investigating officer had observed that the driver of the subject vehicle might have stolen away the subject vehicle and had fled away to Bihar. On perusal of the final report, it was after such observation, comma, the insurance ombudsman had observed that there was criminal breach of trust by the driver of the subject vehicle, which in turn had gone to prove that there were serious steps on the part of the petitioner insured. Post of on perusal of on the perusal of the contents of the final report by this court, comma, it is noticed that the investigating officer in the final report had guessed GUESSE that the driver had stolen the subject vehicle and shifted to Bihar thereafter, comma, along with his family. The offense of quote unquote theft is defined in section 378, comma, Indian Penal Code, full stop, as per section 378, comma, after लिखिए. Section 381, comma, theft by clerk or servant of property in possession of master is an aggravated form of the offense of theft. Full stop. Illustration D. As per illustration D to section 378 IPC, comma, A, capital, comma, being Z's servant, comma, entrusted by Z with the care of Z's plate, comma, dishonestly runs away with the plate, comma, without Z's consent. Then A is to be treated, A, it is to be considered that A has committed the offense of theft. Full stop. In the case in hand, comma, the subject vehicle was entrusted by the petitioner, entrusted to the driver, comma, appointed by him, engaged by him, comma, engaged by the petitioner, engaged by the petitioner, and it was the driver who at the time of, who on 14/10/2016,
Yes, your lordship.
6
2006.
was, and the subject vehicle was in the custody of the driver on 14/10/2006, comma, when the subject vehicle was taken on hire and there was no trace of the subject vehicle and the driver there. In Ratullas Supra, the appellant insured was the owner of a motor vehicle, Tata Sumo, comma, which was used as commercial vehicle for carrying passengers. Full stop. A first information report was lodged before the Nagaon police station on 26/5/2003, alleging that on 24/5/2003, the said vehicle was hired by 4 passengers at about 10 from the taxi stand at Nagaon and proceeded to Golaghat, driven by the driver engaged by the appellant insurer. Full stop. As the vehicle did not return, and in spite of inquiry by the appellant insured, comma, no information could be gathered as regards whereabouts of the vehicle as well as the driver. The appellant insurer, apart from lodging the FIR, comma, made a claim with the insurer as at the relevant time, comma, the vehicle was under a valid policy of insurance. Full stop. After investigation, comma, the investigating agency submitted a report in final form before the court of the Chief Judicial Magistrate Nagaon on 30/8/2003, stating that though the case registered under sections 420 stroke 406 stroke 379 IPC was true, but sufficient evidence could not be gathered against the suspects. The said final report was accepted by the learned court on 24/9/2003. But the claim of the appellant insurer for settlement of claim for loss for theft of the vehicle was repudiated by the insurer on 8/6/2004 on the ground that the driver had committed criminal breach of trust and hence no compensation could be paid. The division bench had entirely observed that the insurer therein is an authority under Article 212 of the Constitution of India, and therefore was amenable to the re-jurisdiction under Article 226 of the Constitution. Full stop. The division bench has observed that the only ground on which the insurer had refused to pay the compensation was that it was a case of criminal breach of trust by the driver. Full stop. It was observed that there was no material before the insurer except the registration of the first information report lodged by the appellant insurer. Full stop. It was found that the insurer at the time of repudiation of a claim, did not take into consideration the report in the final form submitted by the investigating agency under section 173 CRPC, which was accepted by the jurisdictional magistrate, wherefrom it was evident that the investigating agency had reported that the case under sections 406, 423, 79 IPC, though was true, but there was lack of material to prove. Full stop. It was in that context, it was observed that for the purpose of a claim under a policy of insurance, the claimant need not have to prove the factum of theft as required under the criminal law. It would be sufficient if the factum of taking away the insured property by someone, thereby, depriving the insured of it permanently, is established. It was noticed that in the concerned policy, theft was not defined. Full stop. Since the taking of the property with the intention of depriving its true owner permanently, having not been disputed, the appellant insurer was found to be entitled for the compensation under the contract of insurance, and repudiation of such claim by the insurer was found not sustainable in law. Full stop. The division bench directed the insurer to assess the quantum of compensation payable for the loss sustained by the appellant insurer under the policy of insurance and to pay the same within a 2 months period of 2 months. Full stop. Subpara. Reverting back to the facts of the case in hand, comma. The final report had recorded that in the final report, comma, the investigating officer had guessed that the case under under section 381 IPC might be true. Full stop. As mentioned in before, comma, an offense under section 381 IPC is an aggravated form of the offense of theft. Full stop. In the insurance policy, comma, the insurer has undertaken to indemnify the insurer against loss or damage to the vehicle insured thereunder for theft. Full stop. Moreover, illustration D to section 379(8) IPC makes it has clearly demonstrated that a case of the nature case of a case of a case of a nature like the one in hand is a case of theft. Full stop. In such view of the matter, in view of the above discussion, comma, this court finds that the ground taken by the insurer to repudiate the claim of the petitioner that there was commission of criminal breach of trust by the driver of the subject vehicle was in erroneous interpretation of the offense of theft. Full stop. In such view of the matter, comma, the interpretation finding recorded by the insurance ombudsman in that context, comma, is also found to be a manifest error of law. Full stop. Para. The other ground on which the claim of the petitioner was repudiated by the insurer was that there was abandonment of a claim by the petitioner as per policy condition number 7. Full stop. To appreciate the issue, comma, it is necessary to reproduce the relevant excerpts of clause number 7, policy condition number 7 from the insurance policy. No, it is available here somewhere. I have.
There are so many papers, Lordship. No problem. I'll take it back later on.
It is there. Since it is one. Even a science little.
Judgment of Major Thomas.
Somewhere it is.
Lordship can use
Ah,
this.
well, say it, but you want to be there.
Maybe in the file, because Lordship,
No, no, no.
Lordship are looking into that, so maybe in the
Ah.
file.
It is.
Ah. Yes. Read for you. What for you? Huh? From the above policy condition, comma, it has emerged that if the insurer disclaims liability to the insured for any claim under the policy of insurance. No, it envisages three events. First, there is a disclaim of the liability by the insurer to the insured in respect of any claim made under the policy. Secondly, the insured has not made such disclaim a subject matter of a suit in a court of law within a period of 12 calendar months from the date of such disclaimer. Third, in the event a period of 12 calendar months is over from the date of disclaimer of the liability by the insurer, comma, the claim for all purposes is to be deemed to have been abandoned and will not be recoverable thereafter under the policy of insurance. Recourse has been taken to the said policy condition number 7 by the insurer herein to repudiate the claim of the petitioner. Full stop. And full stop. The insurance ombudsman had also recorded that the reason for repudiation by the insurer was that the petitioner made the request for consideration of his claim on 26/3/2010. That is, after 2 years and 7 months. Why you have taken this date?
Because
What is the significance?
I gave a representation by this letter.
Okay.
That was proved in.
Also, the insurance ombudsman had also endorsed the said region in the order award dated 3/9/2013. Poster. Whether such a condition, policy condition, is one has to in this context, comma, a reference to the provisions of section 20 of the Indian Contract Act 1872 appears necessary. Full stop. For ready reference, section 28 of the Indian Contract Act 1872 is quoted herein below in its entirety. Full stop. It is relevant to note that the policy of insurance in the case in hand was for the period
31.
from 31/8/2006 to 38/2007. Exception 3. To section 28 has been inserted by the Banking Laws Amendment Act 2012. WEF 18/1/2013. Thus, comma, the provisions of exception 3 to section 28 is not applicable in the case in hand. As per section 20 of the of the Indian Contract Act, an agreement which limits the time within which a party thereto may enforce his rights under or in respect of a contract by the usual legal proceedings in the ordinary tribunals is void to that extent. What is prohibited by section 28 is an agreement whereby one party has been made to relinquish the remedy by providing that if a suit is to be filed, then it should be filed within a specified time limit, with such time limit being shorter than the period of limitation provided by the Limitation Act. Full stop. If such a clause is inserted in a contract, including a insurance policy, including a policy of contract, it would mean that though the rights accrued continue even beyond the time limit and are not extinguished, yet there is a limiting of the time to sue as prescribed by the Limitation Act. It is such kind of clause which is to be regarded as void by Section 28 of the Indian Contract Act. Full stop. And as such, full stop, in view of when policy condition number 7 in the insurance policy of the case in hand is examined qua the provisions contained in Section 28 of the Indian Contract Act 1872 is considered, comma, the policy condition number 7, which has limited the time for the claimant to pursue the subject matter in a suit in a court of law within a period of 12 calendar months from the date of disclaimer like repudiation of claim, comma, is found to be void full stop. Any reference does, comma, reliance placed upon by the insurer on policy condition number 7 to repudiate the claim of the petitioner is found to be as a result of misinterpretation of law. Later part I will dictate. Later part, that why certiorari jurisdiction is exercised, because it is manifest error in interpreting the law.
Okay, right. But Lordship will give us some time to settle the claim, like in Ratan Das.
45 days
45, 60
from the
days.
date of submission.
Submission I'll
2
do
months.
within
2 months.
2 months. 2 months, because there will be a depreciative amount which will be.
You calculate. I
Yeah,
will
they
not
will
calculate. It is up to you.
They will calculate.
Writ petition is allowed.
DP obligation.
Lordship,
You'll
I
get the order not today.
learned a few things.
I have also learned.
Yes, yes.
I have
yes,
also learned in the
yes.
process.
Yes, Lordship.
Because
from
this exception 3,
Yes, sir.
that finance, you are not within financial institution.
So
That I have checked.
even
Companies law I have checked.
companies
Section 4A.
for it.
And also different notifications.
But-
You are not there. But otherwise, it was inserted in 2013. Your case is of 2006. It was not there in the.
Hmm.
So it,
I
only
got
the main provision was
I
there.
got one Madras High Court judgment. In that also, actually, what happened therein, the plaintiff had filed a suit of reputation. Then the limitation was taken as one of the ground. Then the Madras High Court said, okay, no, that limitation. it
Because
will be-
I have considered this exception 3 in a recent order.
Okay.
Rightly or wrongly, I don't know, but I have,
No, that is correct, Lordship. If it is in banking A, that is correct.
in respect of bank guarantee.
Bank
Whether rightly or wrongly, that is a defined aspect, but this particular clause is void.
Yes.
Yes, madam.
I'll take the book, Lordship.
This
The-
was the first.
the book I gave. Can I take it or it will
Or
be still
insurance booked. Insurance book.
Lordship?
After
I'll
2-3
take-
days, you can get it from the court master.
Yes.
I don't know whether it is available here or not. Right?
No, Lordship can keep it. No problem.
Yes.
With your permission, may I mention item 5? You know, I have to leave there for airport by 3:50. The matter will take time.
Hmm.
I'm taking it.
Highly obliged.
This one?
Item 5.
Yes. When you want. There is an interim order. Yes, where is Mr. Goswami?
Mal.
You are there.
Mal.
Yes. Have you agreed on a common date? Amar Punyas.
Deeply operational. This was my first WBC file when I started advocacy.
Yes, when do you want?
Anything.
Except 9th, my lord.
Except
9th.
23rd February or March? Or 11th of March.
Not, that is not possible. You should have come prepared.
I have prepared, my lord. I have submitted my written arguments also.
No, I don't know. It is not necessary to go through. You wait and 2 o'clock we can take up. 27. 27.
27th of February.
Okay. P. Mehta and counsel for the petition. And Mr. G. Goswami, learned counsel appearing for the respondents. As sought for listing of the case on 27/1/2024. As sought for by the so list the case on so the interim order pass series shall continue in the next date of this.
Great. Lord, can it be on the top of the board because
That no, that the other case is of 2014. That is why it is top of the board.
grateful, my lord.
Yes, Mr.
Item 2 can it be taken up at 2 p.m. your lord? Subject to lordship, what lordship may.
But we will sit late, 10 minutes late.
Lordship.
We have already
I understand that, lord.
1:30 now.
Other side is important.
Yes.
I just met him. He said he was here itself.
Let us first take up this
My lord, I think your lordship's order, which was part that has worked out. So we have given to the deputy commissioner and it was informed that they have stopped it. No event has taken place.
Okay, let Mr. Nath
Yes.
get the report.
Yes,
If that
yes.
is there, then
I
this
told him
particular
also.
incident,
I told him also, he said, yes, there is no event which has taken place.
the other side is absent.
No, I just met him, just on the way. He introduced.
Okay. Because I have asked to give him a status report also. In the
Yes,
event any representation or application is filed by the petitioner,
yes,
and then indicating about the incident scheduled to be held,
yes.
then what action they have
He
taken.
represented as per the orders of the annexed the order. And accordingly, we have been informed that the event has not taken place. That has worked out. The event has not taken place.
But your lordship's concern regarding about what is bullock and what is bull, we find it out, my lord.
Let us see.
Bull and bullock. The
Bull and buffalo.
bull, sorry, bull and buffalo. Bull and buffalo. Court number? He's in court. He's on the way, court number. Bulbul, you just did this. Bulbul to that. This is no, with the buffalo. But if your lordship sees the notification,
Yes.
now, my lord, your lordship sees on the other day, you also just recollect at page 41. Then your lordship has put a query when I have shown your lordship page 41. This is a gazette notification in excess the power under section 22 of so and suppression so and so, except respecting done or omitted to be done before in such supersession. Central government has specified the following animals shall not be exhibited or trained or performing animals with effect from date of publication, namely so and so bull. Then your lordship put a query. But your is SOP is in respect of buffalo. So what a male buffalo, what is the difference between bulls and buffalo? That's what your lordship was putting a query to it. So some research work has been done. And I have seen the judgment of the Supreme Court 2023. And there also it has to be male buffalo, male, not female. Because what I found is a bull is a male bovine. So that include buffalo, that should be male buffalo. Now that should be a male.
My limited understanding, cattle consist of bull and cow. That may be a species. And buffalo may be another species of maybe bovine. There is a genus. Out of the same genus, these cattle and buffalo may be two species. Right. Now,
No. Your lordship can continue. Yes.
cattle consist of bulls.
But I will just add to it. Cattle consist of bulls and buffalo and also cow. That's what my submission is. And ox also. And ox. This is what I'll submit for your lord. And that if your lordship sees 2023 judgments of the Supreme Court, how it has been dealt also. Now, kindly see at page 90.
Paragraph you mentioned.
Yes, I'll just mention it, the judgment at page 92. It starts from 1992. Sorry, 92. Paragraph, it's 94, kindly see, 94, paragraph 2, my lord. Paragraph 2, I'll not trouble all. My lord, I'll just refresh our lordship's memory. There are 3 states, Tamil Nadu, Maharashtra, and Karnataka. Three states have brought in amended the act. And ultimately, your lordship into because A. Nagaraj, looking to the judgment of A. Nagaraj, there was a total ban. Thereafter, they brought an amendment to the act, and after bringing amendment to act, they cured a defect. That is why the apex court said the constitution meant that you can go ahead. Now see at page 93 of this 2023 judgment. At page 94.
You can mention it by paragraph. I am keeping it open.
Oh.
Mention it by paragraph.
Paragraph 2. Paragraph 2. Lordship got it. You just, my lord, skip this. Now next, turn to next page. Paragraph 2. Section. You have got this paper also like this, so it goes well with the court. Judgment. No judgment. Just the court is holding. Court is holding. It's okay. Let me. So if your lordship kindly, now next page, after this notification, lordship got it? This notification issued in excess of power conferred by section 22 of 1960 Act. That is, my lord, gazette notification. And prohibited exhibition or training of bulls as performing animals. However, as exception was carved and it was specified in this notification, bulls might be continued to be trained as performing animals at events such as Jallikattu in Tamil Nadu, Bullock Cart race in Maharashtra, Karnataka, Punjab and Haryana,
Which is,
Kerala.
where is that notification?
This notification at page 41.
No, that is not.
Which one?
That is not. Because notification dated 7 January 2016.
7 January
2016.
or 7 January.
This is 11 July 2011.
Right. That is right.
Nagaraja dealt with
Yes.
was in 2014,
Correct. Right.
right? Thereafter, this notification came.
Yes.
This page 41 notification was before Nagaraj.
Correct. Right. Before Nagras. Right.
So where is that notification? 7 January.
This I have been told that it was withdrawn. This one. Why?
1 second. This notification. My lord, initially they brought this notification and they want to put it, my lord, a defect by curing the defect by way of a notification. So now Jallikattu and all those, now they decided to withdraw the notification by amending the act.
Because but this judgment,
Yes.
judgment.
Yes.
5 judges.
5 judges. I'm
Five
talking about
judges.
5 judges, my lord.
5 judges was determining the question, legality of the said notification.
No, I know. So kindly see, my lord, thereafter. Thereafter, your
paragraph?
lordship has to read. I'll just read the judgment, my lord. However, an exception was carved and it was specified in notification that bulls might be continued to be trained as performing animal at events such as Jallikattu in Tamil Nadu, Bullock Cart in Maharashtra, Karnataka, Punjab, Haryana, in a manner by the custom of common community or practice, tradition and a custom or as a part of culture in any part of the country. In state of Karnataka, now my lord, you kindly mark this. In state of Karnataka, the race involved male buffaloes, known in the state as Kambala. So lordship will kindly mark this. So male buffalo, known in the state as Kamala. This exception, however, was made subject to certain conditions, seeking to reduce the pain and suffering of bull while being used in such sports. A batch of writ petitions so and so were instituted before a division bench of this court. Question legality of the said notification. The petitioner in those proceedings also sought compliance with direction of this court contained in case of so and so. The first batch of writ petitions brought by Animal Welfare Board, other including one so and so. Course of hearing, the Animal Welfare Board changed its stance and sought to support the stand of the state and Union of India mainly on the ground 1960 Act and certain state amendments which were enacted in the year 2017 were not repugnant and the board has framed guidelines to prevent suffering of bovine spices during holding of the aforesaid event. We shall refer to these 3 state amendment acts later in the judgment. However, the second writ petition so and so practicing also a member of board prosecute the aforesaid writ petition as a single writ petition. In this connection, so and so interrogatory application was filed by so and so on the strength of being an agriculturist in Maharashtra. He has argued a challenge to the Maharashtra Amendment Act if sustained could hamper lives of farmers since still associate bullock cart race. It is also his argument that the Amendment Act of Maharashtra is also relatable to entry 15 of the list 2 of the 7th Schedule of Constitution of India, which stipulates yes, so and so. Now, my lord will the Prevention of Cruelty to Animal Tamil Nadu Amendment Act, the Prevention of Cruelty of Animals, Maharashtra and Amendment Prevention 3 Acts were enacted by the respective state legislatures and received presidential assent. We shall refer to this acts in greater detail in judgment. These amendments act is substance seeks to legitimize various types of bovine sports, including Jallikattu in Tamil Nadu, Bullock Cart race in Maharashtra and Kamala in Karnataka. Term Jallikattu as defined in Tamil Nadu Amendment Act as follows. So and so, my lord, so in the Karnataka, so all these 3 acts
my lord, has been here specified what was there. Kamala, Jallikattu, and bull race or Bullock race. Now, my lord, we'll see next 6. A public interest litigation was brought before the High Court of Justice Bombay, registered as PI, State of Maharashtra, challenging certain proposed rule brought by State of Maharashtra under the heading Maharashtra Prevention of Cruelty to Animals, Conduct of Bull Cart Race Rules 2017, permitting bullock cart race, and on 11 October 2017, High Court restrained conducting of bull cart races within the state of Maharashtra. The aforesaid rules sought to regulate organization of bull cart race. A farmer from the state, from the district of so-and-so, issued a special leave petition, assailing that the order passed by Bombay High Court and in this reference we shall deal with certain point raised in the state special leave petition as well. A division bench of this court by an order passed on so and formulated 5 questions to be answered by the constitutional bench, and the papers are directly placed before the Honorable Chief Justice. Division bench had formulated the following 5 questions which we have to answer in the judgment. So this 5 my lord question was formulated, which was placed to the Honorable Chief Justice. Now, my lord will kindly see, skip this. Now, my lord will kindly para 12 kindly be looked into it, my lord. Para 12. Para 12, my lord. Lordship, what is para 12? Para 12. Lordship, what is my lord? The 1960 Act has been enacted in personal register power containing so and so. Impact of the Amendment Act on the main statute revealed from the following comparative table given below. If your lordship kindly see the first, second, third, fourth, in particular, the Prevention of Cruelty to Animal Karnataka, your lordship got it. Second Amendment Act 2017. Kindly turn to next page. That is bulls whether tried. See, my lord, there is a column. That is first, second, third, fourth columns. Bulls whether tried to cart with the help of wooden yoke or not, in whatever name called, normally held as a part of traditional culture in state on such days as places as may be notified by state government, and Roman 2 after clause D. The following shall be inserted, namely DD, kindly note down. Kamala means the traditional sports events involving buffalo male. Lordship got it? Buffalo male. Race normally held as a part of tradition and culture in the state on such days and places as been notified by the state.
That is specifically paragraph 5 is there.
Yes. Paragraph 5.
DD is there.
Yes. Now, my lord will kindly see another notification code. Notification code. Where is the notification? Now, section 11. Section 11, I don't know how it is. Para 12.
Prevention of cruelty and cruel.
Internal page 16, my lord. Internal page 16.
Which section?
Para 12, section 11. Para 12 of the judgment. Para 12.
Para 12 of the judgment.
Yes, that is internal page 16 will be. Internal page 16. 16, section 11. On the left hand side of the column, section 11. And if you leave after section 11, next, first, second, third column. Third column. Kindly see F, my lord. The conduct of Kamala with a view to follow and promote tradition and culture and ensure preservation of native breed of buffaloes, as also their safety, security, and well-being. G, the conduct of bulls race or bullock cart race with a view to follow and promote traditional culture and ensure preservation of native breed of cattle. Lots of got it. Native breed of cattle and also their safety, security, and well-being.
One.
So I think this is
1 minute.
yes, yes.
Yes.
Your Lordship is looking section 11, Your Lordship looking. Your Lordship, that's query, I have to meet out that query. Your Lordship is troubling Your Lordship, mine is about regarding 7/1/2016 notification. 7/1 in the judgment, Your Lordship read in paragraph 2.
Because that was question.
But what has happened, my lord?
What has
this-
happened to that result?
Yes, now this, my lord, on this is 7/10, this is on 31/10/2017. 31, that notification was on 7/1/2016. That in
Yes,
the judgment,
yes.
7. So your lordship has said that your gazette notification which you have showed is 2011.
Yes.
2011. But this notification of 2016.
Okay.
This
Can
2016.
I have a glance? Can I have a glance on that
Glance,
notification?
notification. Can you show the notification? Not in the order, but we have to get that notification. But
Because
that
we are into performing an email, one part.
Wha-
I am still
correct. No, that's what.
bull and buffalo.
Yes,
I'm not convinced,
yes.
right? History is one part.
Yeah.
History, heritage, culture, that is one part, custom, right? But still, what is troubling is that come to page section 22,
Section 22. Yes,
chapter 5,
chapter 5. I got it.
performing animal.
Correct.
22, Roman 2.
Roman 2.
No person shall exhibit or train
Yes.
as a performing animal any animal which the central government may by notification in the official gazette specify as an animal which shall not be exhibited or trained as a performing animal.
Right.
Leaving apart definition in section 21.
Yes.
Section 21 says about exhibition
Right.
and by sale of tickets.
Yes.
Let us
Let-
forget for a
yes.
moment. Now, it is the central government who will say and notify that these are not performing animals.
Yes.
Is 41 notification.
I understand.
It
That's
is
why
not
your-
the other way
No,
around.
your lordship is
That
worried.
central government,
No, I know. Your-
just for a moment, central government will specify that these are not performing animals, meaning thereby that the remaining is performing animal or not, that has not been decided. It is
Correct, right.
final authority is central government.
Yes, right.
They will specify these are not.
So what your
Or-
worriness is that if these are not performing animals, then in gazette notification say this cannot be performed. So it gazette notification last is bulls. So your lordship query was why not bull is not a performing, but what about buffalo? It is not been notified. That's what
That's what your lordship is troubling. That's what is
Simple,
lordship is troubling. So what I
agree to-
draw. When this act came, then it is, this notification was this way.
Because Nagarada
Yes.
is specifically as regards bull.
But yes, now.
Go to the entire judgment. There is not a whisper about bull.
But 2000.
Sorry,
Buffalo.
buffalo.
Yes.
Then this notification came.
Yes.
If you see the definition of exhibit and train,
Yes.
then if you read this notification,
Yes.
then it speaks about that bulls are not performing animals,
Yes.
but there is an exception carved out, Jalikatu, Maharashtra, Karnataka, so and so as a custom.
Correct.
Right? So this was under the Prevention of Cruelty to Animals. And thereafter, all these state amendments
State amendment
have
took place.
come under Article 254
Four.
to bring out the exception.
Exception.
Basically.
Yes.
After presidential assent.
Correct. Right.
Right. Now that Constitution meant tested the validity of those constitutional amendments
Yes.
as well as this. But with the constitutional amendment under Article 242,
Yes.
it appears to be, it is still in force because central government has the power to decide about performing anything.
Yes.
But because of entry 17 of list 3,
Yes.
they have taken the presidential assent for the state amendments. But still, we go back to the basic question.
Yes. Even
This
only three
bull and
states.
buffalo,
Yes.
are-
I understand this
and
trouble.
secondly, where does it, the central government banned
But that's
buffalo as a, that this is
no,
not
no,
a
my lord.
performing animal.
That
We have to
particular
take a call.
that particular is not decided whether these were bulls, buffalo, similar. Because if bulls and buffalo is similar, with great respect, I will say, because 23 judgment also buffalo has been defined. Buffalo has, Kambala is my buffalo.
Thus, the definition was there. Where is the observation of the Supreme
My
Court?
lord, so many words
No,
you will not get so
we
many
need
words,
to-
my lord.
Uh,
In
we
Supreme
cannot
Court.
infer everything.
No, no, we will read
There
the
has to be
judgment.
specific.
No, we
Where is
read
the
it.
in the judgment constitutional man judgment?
we-
It has dealt with buffalo.
Yes. Now I will
Still,
just
there
no.
is that request to be examined in the context of Section 11.
Yes.
Definitely,
See,
that is a case to be
so
examined.
no, what is your troubling? There are two aspects of this case. One is about the gazette notification, one is bull. Your lordship has to be satisfied. Then bull and buffalo, male is a male bovine, so it is buffalo, male buffalo. Then, my lord, the question, if your lordship is satisfied, then, my lord, gazette notification will stand. Then it is not a performing animal. I'll just
Otherwise, having, because this question was troubling me also, that bull and buffalo are the same or not, right? I have found, subject to correction, that bull and buffalo are not same.
but with great respect.
Bull is, with great respect, it is domesticated animal.
But I will-
Buffaloes are wild as well as it can be tamed.
then
And even, Mr. Das, I have gone to the extent
Yes.
that in Mahabharata also buffalo
yes.
they are said to be wild animal. In Ramayana also.
But then
That is a big history.
my
And
lord,
Mr.
I know, my lord,
Das,
we also, my lord, we have also
have to-
made a research of
we have to
this.
point out we want to point out because
No,
there is a Central Institute for Research on Buffalo.
my lord, this is work done by one of the animal Rahat. Research has been done and there's a note which has been brought.
There is a central government institute itself. Central government
Yes,
for Central Institute for Research on Buffalo. There is a central government institute.
we'll find it out. We'll find it out.
It is
My
a
lord,
central-
we don't want also, my lord, it is to be foolproof, my lord. That's whole case, my lord. But what I was trying to justify your lordship about the judgment of the Supreme Court 2023.
Yes.
Your lordship
Yes,
differs it,
sure.
saying that no, Buffalo, we will not go into that because Buffalo
No,
has
I'm
not
not,
been.
Mr. Das, we are not.
No, no,
saying
what-
that
no, no,
we
what-
don't have a case.
No, no,
Ah,
I said.
we are
because-
examining this race also for 10 days.
Yes,
From the context of not holding Buffalo fight, even for a period of 10 days.
Hmm.
Right?
right. Absolutely correct, my lord.
There is no urgent necessity in the
Yes.
month of February.
No, correct. Your lordship is
Right?
Right, I also
That
felt.
is why I'm.
No, I also felt. That's your lordship is right. My lord, we have to be.
And if some sporadic incidents comes to light, definitely
No, no,
liberty will be
My lord, your
granted
lordship.
to you,
My lord,
like the
lordship.
one
Yes,
you brought it to light, that will be open for it.
yes.
But we have to test the validity.
100%. Your lordship is sitting and testing it. It will go.
But
Your lordship
definitely
has
you will
to
have
test it.
option because
No, what?
as of now, two things have not been, I'm not very much sure because I don't have that knowledge also. It has to come from an authority.
Yes.
If you have any authority,
Dictionary definition, we find it out. But we have to put a note twice. So we have to put the note twice. Have got it? Only for a moment. If
Will-
you-
Mr. That's what I propose. On every date, this prayer, this will be strictly enforced, not twisting the challenge to the SOP.
Right.
Okay.
Right.
And prayer for interim relief will be considered on, will be left open for consideration, and every day you come with some authority, we'll do it. Otherwise, I feel whether any amendment,
Hmm.
because Constitutional Bench has given the
Yes.
affirmation to the state amendment.
Yes.
The question is whether in the absence of any amendment act by the state
Yes.
under Article 254,
Yes.
this kind of SOP
SOP
is
is sustainable-
sustainable or not?
sustainable.
This is the question.
This is the main question.
Mr. Damish.
That's the whole question, my lord.
This requires also response
No,
from their side.
definitely, my lord. On the face of it, if you see those three acts, my lord, why the Supreme Court has interfered?
And-
Supreme Court said, because they brought an amendment, they took the assent of the president. That's the difference. My lord, if they bring it, that's a different thing altogether. As on date, they have not brought it. It's a cabinet decision has been
Right.
taken, and on the view of the cabinet decision, this is notification SOP has been issued. That's why we are before this court. But your lordship troubling is about bull and buffalo. That's the main.
And
Now,
secondly,
why? Suppose today-
secondly, consciously or not consciously, not declaring buffalo as a non-performing animal by the central government under section
no.
22.
now let us see, because you will not, my lord will not get exact. I tried like anything to find it exact. We don't find exact everywhere, my lord. So inference has to be
So,
drawn.
Mr. Das,
No, I'm sorry to
this
say.
court
No, I'm sorry
this
to
court-
say, my lord.
and Mr. Nath,
Yes,
or maybe Madam existing you,
yes,
all are not authorities on buffalo or
Yes.
bull. We'll keep it open. As
Yes.
soon as you come up with some authority that yes, bull and buffalo are one and the same, and buffalo is not a performing animal, then
suppose.
we keep this interim relief open on every date.
My lord, will for a moment, my lord, if your lordship give me 5 minutes. My lord, kindly see this for a note which has been prepared. Kindly see, my lord. See definition, my lord. Lordship got the definition. Lordship got it, my lord. On its page, in referring to male buffaloes, the Indian Council for Agricultural Research, Central Coastal Agricultural Research Institute, used term bulls, buffalo as well as buffalo bulls. ICR is an autonomous organization under Department of Agriculture, Research and Education, Ministry of Agriculture and Farmers Welfare, Government of India. Definition of bull in both and reputed so and so, as well as Oxford English Dictionary, male bovines, including male buffaloes.
This is bovine.
Yes, yes,
That is a genus.
yes. Exactly what we are saying. The genus.
Genus.
Male bovines.
Not species.
Bovines, including male buffaloes. See now.
Mr. Das, you must have been to Spain.
I'm sorry.
Must have been to Spain.
I have, yes.
So
Yes.
what was the
That's a bull.
festival?
That's a bullfight, my lord.
Bullfight?
Bullfight. That's a bullfight in Spain. My lord, I'm sorry for troubling. For a moment, kindly see page 95 of the judgment. See, please. Internal
Paragraph?
place 4. Internal place 4.
Paragraph.
Paragraph 3, my lord. Your lordship is holding that small, yes. Internal page 4. 4, no? See,
Page 4.
para 3. Para 3. Lordship, I'll just read this, my lord, which makes it para 3. Lordship got it? The first of these writ petitions brought by Animal Welfare Board, other including Ma Anjali Sharma. But in course of hearing, the Animal Welfare Board changed its stance and sought to support the stand of State and Union of India, mainly on the ground in 1960 Act and certain state amendments which were enacted 2000 were not replicant and the board has framed guidelines. To prevent suffering of the bovine species during holding of the aforesaid events, we shall refer to this act, bovine species. So what we are saying, these are bovine species. And is a bovine species.
Totally agree.
Yes. So if it is a bovine species, my lord, species, bovine species. So what we say, bovine species, that also, my lord, it should be a male buffalo. That's what we are saying, my lord. All males, it cannot be female, all males are bulls, my lord. That's bulls. Bulls, maybe. That's my lord, what I found in 2023 judgment of the apex court with great respect, 5 judges. One is bull, one is perform bull, that is Jallikattu. One is, my lord, Tamil Nadu, where Kambala, it's a buffalo, male buffalo. So if I draw an analogy, there, my lord, there was no discussion saying that it is not covered because there was a strong argument placed before the court that performing animals, that they said, how can you do it? It's not exhibited. Like your lordship said, forget about the exhibition part. Forget about the exhibition part.
Otherwise, in colloquial, in Assamese language,
Yes.
bull is called harguru,
Yes.
and buffalo is called mob.
Yes.
So it is very easy to find a distinction.
Yes.
By authority only we can get it together.
Because what I found,
We'll test.
So para 31, kindly see. Para 31. Internal page 43, my lord, of the judgment.
31.
Yes. That issue, my lord, your lordship will look at, that issue was not taken up by the Supreme Court. This issue was never taken up because the buffalo came, male buffalo, about Tamil Nadu, but this was issue which has been lordship, definitely your lordship look into it. But this issue was never, they cropped up in the apex court.
Neither in Nagaraja,
No,
neither
it
in
wasn't cropped up.
constitution bands. That is why.
But today, as on date also, my lord will kindly see. That's what I have read, my lord, male buffalo. So we are taking, my lord, wherever the judgment of Supreme Court is there, we'll definitely take the help of that.
Otherwise, there has to be independent application of mine.
See, kindly see.
Okay, 1 minute.
Yes.
What about bull is, sorry, buffalo is 15 January to 25th January.
25th January, right.
neither this way nor that way,
Yes.
only 10 days.
Right, correct,
Right.
right.
And what about Bulbuli?
Yes, that they have not spelled out any particular dates. So now, my
Mr.
lord,
Nath, do you have the complete notification with you?
But no, but I at this moment I don't have.
but there is one difficulty in Bulbul. My lord, kindly take up Bulbul, my lord, for a moment.
In SOP?
SOP.
Okay. It is there.
See, background of Bulbul birds fight. Date is not been mentioned.
That is what I'm looking
Not
at.
been mentioned. Although there was no documentation about Bulbul, started old times say it was started.
Because
with grape.
page 1 and page 2,
Yes.
something is missing.
Which one? No, we got it. You have given. Whether you typed out. Or typed out full Bulbul, you have a typed out and give it. Only 14. Half-hearted 14. But you get it. But you have it's your case. Please get it.
Because Bulbulify
Yes.
this SOP,
Yes.
if you come to page 42,
42.
42 of the first one.
42. SOP, my lord.
SOP.
My lord, about. Your lordship taking that code double
Both are
C.
same perhaps. SOP is same.
Yes, SOP is same.
One and
One,
only.
Right, right.
Yes, yes.
40?
SOP is one, no?
42 in the Buffalo petition.
Yes,
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 40.
yes. Right.
We'll start with Buffalo petition and Bulbuli.
Yes,
Bulbuli
right.
petition.
Yeah.
Lot.
Now in the Buffalo petition, page 42.
Yes.
42, yes.
Background of Bulbuli bars fight,
Yes,
right?
yes.
This one paragraph is there,
Yes.
right?
Hmm.
Then somehow next page, if you turn to next
I've
page,
seen that.
it's
Somewhere it is missing.
somewhere-
Somewhere it is missing.
something
Some
is-
part is missing. Some part is missing.
But otherwise, it speaks about Haju town only.
Oh, yes, only Hargam. Hygrid mother Mondir Milo.
So if
That only performed
if
there.
Bulbuli is only confined to Haju
Yes.
during
Date I don't know. Date which they have not given.
during Magh Bihu perhaps. Bhogali Bihu.
Bhogali. Bhogali.
Bhogali Bihu.
Yes.
During
Yes.
Bhogali Bihu celebration
Yes.
every year.
But if your lordship kindly see what I found, subject to correction by your lordship, kindly see Wildlife Protection Act, my lord, for a moment. Bulbuli is concerned, my lord. Now, if your lordship kindly see 9, section 9, Wildlife Protection Act 1972. See 9. Lordship got it? That's what your lordship is taking 2023. 2000.
2021.
No, I will just, I ask him. We will give it, my lord. We have got that. Kindly see section 9, my lord. Section 9. Prohibition of hunting. No person shall hunt any wild animal specified in Schedule 1 and 2, except as provided under Section 11 and 12. Right, my lord? So if you see Schedule 1 and 2, kindly see the Schedule 1 and 2. Birds. Schedule 2.
Will start
Uh,
71.
I don't know the same one icon. Same icon.
Part A mammals,
Part
Schedule 1.
Part A mammals. Then you lordship, please go into further. Part B, kindly see Part B birds.
Part B.
Birds. Lordship, what is birds?
Birds.
Please now go further. See page. It's Bulbul is written.
Serial
Somewhere,
number?
It's before 49. 50.
449.
50 Bulbul. Then 50. It start. See
What
Bulbul.
is the main hornbill?
Yes, broadbills and bulbuls. After broadbill, bulbuls. After bills, lordship got it, broad bills. Your
Here,
lordship is
fif-
birds,
Huh?
birds, Part
Birds
B,
I-
birds,
Birds, yes.
barbets, barn owls, bee eaters. Lordship got it?
Part B, birds. Okay. What is the main heading?
I'm sorry.
What is the main heading?
Heading is part B, birds.
Part B, birds, then
Yes.
barn owls.
No, you forget, not barn owls. Go further.
Yes.
Bulbuls. You see, my lord, bitterns, herons, and egrets. Lordship got it? Northern storm petrels, broadbills, and bulbuls.
Owls.
24. Bulbuls.
Trying to find out. Near about serial number?
This is schedule 2, serial number from 50 it start. Bird serial number 50 it start in my book. 50.
50. 50 is river and turn. Then next heading is hornbills.
Hornbills.
Mr. Das, why don't you mark here in
Yes,
this book?
yes, Mark, hold yes, Mark, will mark.
Mr. Das, it was incomplete.
Yes. Which one?
Your SOP.
Yes. SOP we got it, my lord. Dile na SOP na? View of the order passed by Honorable Supreme Court SLP. Animal so as a government of Assam issued an order dated prohibiting bulbul fight during the festival of Soens of Bihu. Temple committee challenged the ban imposed of Guwahati High Court. Honorable High Court by order opined the Supreme Court decision rendered in the context of injury inflicted on racing bulls cannot be justified by banning the ritualistic birds fight in Sri Hoygabri Mandir, Mahadev Mandir, Madhavdev Mandir premises and kept the ban order dated so in abeyance until further orders. Until further it was kept in abeyance.
Which one?
There's bulbul fight.
No.
There was a ban.
Order opined that
Yes.
Supreme Court decision rendered in the context of injury.
Inflicted on the racing bulls cannot be justified for banning the ritualistic birds fight. Lots of got it? In so and so premises and kept the ban order dated in abeyance until further orders.
Whether that this revision was decided or not decided.
That is not.
There is very recent order 22/12/2023.
Yes.
Yes,
Cannot be justified for banning ritualistic bird fights.
yes. Now my
That there is the observation of the coordinate bench.
now my lord, that's why I'm saying my lord, it's a single bench. So your lordship is on a single bench. Now coordinate bench, maybe. Lot of things were not brought into before this court. That's why, my lord, this why I'm trying to justify the Wild Protection Act. For a moment, kindly look into it, my lord. Lordship will take a call, is a different thing altogether, coordinate bench. This, my lord, issue, this was not brought into the court. The act was not brought into the court. This act. I have not found, my lord. Kindly see, my lord. Kindly see.
Otherwise, Mr. Das, you should bring this total SOP, entire SOP on record by way of or replacing this SOP.
We'll file an additional affidavit.
Replacing this SOP
Yes.
because we.
I'm so sorry, my lord. We'll bring. Incomplete, what my learned friend is saying, my lord. We made an RTI and we got an incomplete RTI. That's what my learned friend has said, my lord. Now, lordship got it, my lord. Mark. See, bulbul, my lord. Lordship got it? Yes. Now, see, red vented bulbul. These are all bulbuls, my lord.
So, Mr. Das,
Yes.
so far Bulbuli fight is concerned,
Yes,
this is limited to Hoygrave Madhav temple
yes,
during Bhogali Bihu
yes.
and nowhere else.
It appears, I know,
observe-
because your lordship, we came with Buffalo fight, in spite of the SOP, somebody was holding it. So your lordships, then we said that how can they hold it? So we don't know which party they are holding. Normally it is reflected here is only that period. That's right, Milo, that period. Now, only
Two
for a
things,
moment.
Mr. Das, what we propose, because
Now, kindly, my lord, for a moment, if your lordship will kindly see this for a moment. 2 minutes, I'll just trouble your lordship.
this I have found. This I
Kindly
have found.
see prohibition 6C section 9, my lord.
Yes, I have found.
Prohibition of no person shall hunt any one animal specified in schedule 2, 1 and 2. Right now, if your lordship looks into definition, kindly see the definition of hunting. That is section 216. Section 216. See section 216. 216. 16. Definition hunting. Hunting with grammatical variation and cognate expression includes killing for this not B capturing. So you cannot hunt for the purpose of capturing, and these are restricted in Schedule 2. So this, my lord, with great respect, was not brought before the learned single judge. This is what we'll try to bring the writ petition also. We'll see, my lord, all these were brought into notice or not. My lord, if you cannot hunt, that is prohibited under Schedule 2, there is no question of capturing it. This is
Observing the said judgment or order
yes,
par incurium
yes.
to a statutory provision at the motion stage is difficult.
No, I understand. I understand fully, my lord.
That's true.
I understand. What I will try to pursue your lordship is regarding this. Your lordship is because there is a coordinate judgment order. But what end result, you find it out. What is the end result, we don't know. Secondly, my lord, we found that these are statute which was not brought notice to dictate. Wildlife
If
protection.
certain statutory provision is not brought to the notice of the court,
Yes.
a judgment is delivered.
Yes.
That judgment will be treated as par incurium to a
That's why,
statutory
my lord,
provision.
let us go
That,
into it.
that issue will be open,
Yes.
but at the motion stage it will be difficult.
Yes.
Otherwise, you will observe in the order now
Yes.
that by the SOP,
Yes.
the Bulbuli fight was only confined to Hoygiri Madhav during Bhogali Bihu.
And one more,
During Bhogali Bihu.
one more
And
condition
in
is
terms of the order, it is so and so.
Yes.
Your commission regarding section 9,
Yes.
read with 216,
Yes.
read with schedule 1
Yes.
or 2,
Two.
part B
Yes.
will record.
Yes, correct. my lord.
one more
Correct.
condition. One more
And
condition.
So that issue,
That's why
and
issue will be open.
secondly, that notification that whereby this SOP have been brought
Yes.
is to be tested in the context of whether without bringing any amendment
Yes.
to the prevention of cruelty to the animals act by Article 254, 2 or 3,
Yes.
this kind of
SOP can
SOP
be
by way of an executive instruction
correct. Right.
can be
right,
valid. That is the issue.
Right. That's the issue. That's the issue.
Yes, Mr. Nath. What about this Morigaon or Ahadguri, something like that? Any report?
That Nagav, yes, no, that report I have seen.
Only I'm worried. Lot of districts are there. We don't know also which events are going on. It's lucky that we brought it and there is some observation. So at least, my lord, government will ensure these type of events are not being held. They can keep it track. Your lordship can observe that.
I'll observe.
Yes,
Okay,
that observation will help us. That only observation.
So it was not
The
held.
No, it was not held.
Or Mr. Dijas in the eye.
But the SOP provides one for more condition, Miller. The last sentence, both buffalo and bulbuli fights shall be permitted only at the places where both the fights have been traditionally conducted for last 25 years. That is also another aspect.
I heard Mr. Dijas, learned senior counsel, assisted by Mr. DJ Das, learned counsel for the applicant with petitioner, and Mr. D. Nath, learned senior government advocate, Assam, for the opposite party. That's response number 1 and 2.
Mano, only one, Mano, her name is A. Kedia.
Oh, MS?
A. Kedia. A. Kedia.
A. Kedia. Mr. Das, learned senior counsel, has submitted that. Pursuant to the order dated 1/2/2024, the applicant writ petitioner submitted a representation before the district commissioner Nagaon, stating the details where a buffalo fight module was proposed on 4/2/2024. Poster. Mr. Nath Lanet, Senior Government Advocate, Assam, has placed a communication bearing number so and so dated 5/2/2024, addressed to him by the District Commissioner Nagaon. Poster. Mr. Das or Nath has further submitted that a report, Office of the Deputy Commissioner, District Commissioner Nagaon, obtained a report from the Superintendent of Police Nagaon reporting that no buffalo fight was organized on 4th February and 5th February 2024 at Hatigor Hingibari Pothar under Nagaon district. It was further reported that by the Superintendent of Police Nagaon, a copy of which has also been enclosed therewith, that the organizer did not seek any permission for holding buffalo fight in any area within Hatigor, Hingimari, Pothar, Nagaon district. Mr. Das, Senior Counsel, waiting for the Senior Counsel has submitted that the applicant petitioner had also made an inquiry and had found that the holding of buffalo fight at any place within Hatigor, Hingimari Pothar district, Nagaon on 4/2/2024 could be prevented.
Yes.
In view of the above, this court is of a considered view that since the interlocutory application has been preferred in respect of a particular buffalo fight proposed to be held on 4/2/2024, and finally, no buffalo fight module was held on 4/2/2024 at the place indicated in the application, this application is closed. Bull buffalo. Heard Mr. DJ Das, D Das, Senior Counsel assisted by Mr. DJ Das and MS Kedia, Learned Counsel for the petition. And Mr. Dinat, Learned Senior Government Advocate Assam for the respondent 1 and 1. The petitioner in this petition has assailed a notification, page 42, bearing number so and so, dated 27/12/2023, issued by the Political A Department, Government of Assam, whereby the state government has issued 2 has inter alia issued standard operating procedure within bracket SOP stroke guideline for modules within bracket Buffalo Pine. It all 466 ঠিক আছে 468 লিখিব standard operating procedure stroke SOP for bulbuli birds ঠিক আছে the notification stroke SOP stroke guideline for modules Buffalo Pine are assailed on a number of grounds. ঠিক আছে it would লিখিব বুলবুলি বাস পাই ঠিক আছে by the firstly it has been condemned that it has been on a number of counts. One, that without as the sorry the guidelines stroke SOP stroke sorry the notifications stroke SOP stroke guidelines are clearly in violation of the provisions of the Prevention of Cruelty to Animals Act 1960. Second, second, the state government could not have brought such a notification, stroke SOP, stroke guideline, without bringing any amendments to the Prevention of Cruelty to Animals Act 1960 by virtue with the without any presidential assent under Article 254 of the Constitution of India. As the Prevention of Cruelty to Animals Act 1960 is a central legislation and is under entry 17 of list 3 there's concurrent list of Schedule 7 to the Constitution of India. That the same that the notification strokes are also in conflict with the judgment of the Honorable Supreme Court of India in Animal Welfare Board of India versus A. Nagaraja and others reported in 2014-7 SSC 547 and the Constitution Bench judgment in writ petition civil number 23 of 2016 within bracket the Animal Welfare Board of India and others versus Union of India and another comma or bracket close comma decided on 18/5/2023 that Buffalo is Buffalo comes under the bovine species, and as such, it cannot be a performing animal. Any other ground? These are the broad grounds. Mr. Nat, Senior Government Advocate, Assam, supporting the notification, stroke, SOP, stroke guideline. বুলবুলির আটা লিখিব এইটো হেৰি লিখিল ন এইটো যে এইটো লিখিলে বভাইন স্পেচি এইটো বাফেলো লিখিব তাৰ ৰিপ্লেচ কৰি ইফালে বুলবুলি লিখিব বাফেলোটো হেৰি লিখি নিদিব এই বুলবুলি any event of bulbuli fight will amount to violation of the provisions contained in section 9 RW section 2 within bracket 16 RW schedule 1 schedule 2 part B to the Wildlife within bracket Protection Act 1972. Bulbuli, huh? Supported the Swenson by contending that the region for holding permitting buffalo fight at specified places have been indicated in the notification itself that buffalo fights are permitted only within a specific time period of a year, that is within 10 days succeeding Magh Bihu within bracket from 15 to 25 January. And no modules is allowed at any time except the time period from 15 to 25th January. Etu mohot likhibo. Bulbuli likhibo. That bulbuli fights is permitted only during the festival of Magh Bihu, that too, at Sri Sri Hoyagriva Madhav Temple at Haju. Bulbulita outer likho. That this court, in an order dated 22/12/2023, passed in WPC number 5228/2015, had observed that the Supreme Court's decision rendered in the context of injuries inflicted on racing bulls, cannot be justified for banning the ritualistic bird fights at Sri Sri Bagriva Madhav Mandir premises. That whether the state government would require to bring state amendments under Article 254 would is a matter required to be tested. Issue notice returnable on particular as Mr. Matt appears accepted, no formal notice. Extra copies by tomorrow. The petitioner shall take steps for service of notice upon the response number 3 by registered post to AD. Post para. The matter issue notice matter would require a detailed examination. Post of the issue notice. Be that as it may, very likhable. Buffalo. Notwithstanding the legality and validity of the notification stroke SOP stroke guidelines for Mojus buffalo fight, it is evident that the state government itself has observed that no more buffalo fight Mojus will be permitted in any other period other than 15 January to 25 January in a year at any other place. Thus, this court likes to observe that the state government shall ensure strict compliance of the notification stroke SOP stroke guidelines in respect of Mojus buffalo fight poster. ঠিক তেনেদৰে অগ্ৰিম মাতত বুলবুলি ডিউৰিং ভোগালী বিহু তাৰপিছত লিখিম if any other it is open for the petition. If any such holding of any such Mojus or buffalo fight.
Mojus and bulbul.
No, separate.
Oh, separate.
Otherwise, he will get confused. Comes to the light if any information as regards holding of Mojus or so and so is received by the petitioner. It is open for the petitioner to bring the same on record by appropriate pleadings.
Yes.
Right?
Yes.
That IA is open.
Correct. Right.
Then similarly, Mojus will be leakable. The matter of consideration for interim prayer is left open. Is the further interim prayer is left open for consideration.
Yes. And my lord, we will bring that additional affidavit by way of enter SOP because incomplete.
The petitioner on the prayer being made, the petitioner is permitted to bring the entire notification stroke, SOP stroke so and so by way of an additional application.
My right.
Do you ensure?
It is
Bring it to
otherwise-
light whenever
Yes.
any event is organized by way of an IA.
Yes.
Try to.
It is our SOP is very clear. SOP is very clear.
Fourth, my lord, the matter is this. Fourth, my
4th
lord.
of March.
Fourth of.
No.
Deeply obliged.
You take steps, Animal Welfare Board of India, and find out this central institute. If they are the authority
They will
on
find it.
Buffalo,
Yeah, we'll find it out.
they will cleanse the issue.
Yes, yes. Deeply obliged.
Yes, Mr. Where is M? Oh, you were there. Okay. What prayer you made, Mr. Tolia? At 10:15, MS Bormon had made a prayer
My lord,
since you were absent,
my lord,
both of you.
my lord.
So I think what you have
Yes.
submitted,
Yes, my lord, that one signed copy has been received, but second copy in original signature.
file the
Very soon.
affidavit.
So I need one day accommodation.
But
only.
I have gone through. This is a disputed question of
My
fact.
lord, it is can be remarked that.
Disputed question of fact,
My lord, my lord.
Mr. Bhuya.
My lord, we are not.
So if that affidavit throws some light, I don't know what is there in the affidavit, but if that affidavit throws some light, then only we can consider it. But because we are not here to decide the land dispute.
I am not the writ petitioner, my lord. I am,
No.
my
There.
senior friend is the writ petitioner, my lord.
So let the affidavit come
By
on record.
tomorrow.
By what time you want to file?
By tomorrow, my lord.
By tomorrow.
Then a short date, short.
You have
date.
waited so many.
Maybe taking
Fine.
up on
You
Thursday.
can wait. No, not Thursday, not possible for them.
On my.
Next Tuesday, my lord.
Yes.
Next week Tuesday, my lord.
You
Kindly.
have to think about the business of the court also.
My lord, I have seen.
And it is not, yeah,
My lord.
it is not a matter of such emergent nature which requires top of the list hearing.
We are lucky today, my lord.
Mr.
It is item number 4
DP
today.
Solia. Ms. M. Mormon Lawrence, Junior Government for the State Respondents, and Mr. A.R. Bhuya. Lawrence Council for the respondent number.
My lord, 5.
MS Bormon has submitted that.
My lord, I am respondent 10, my lord.
10.
My lord.
MS Bormon has submitted that the affidavit of the state respond number
Oh, my lord, deputy
4.
commissioner
Will be filed
tomorrow.
by tomorrow by serving copies of the same to both Mr. Solia and Mr. Bhuya.
My-
Full stop. Please the case. 6. 15. Obliged. 15. Production number. Keep production.
Lordship, the petitioner before your lordship is a lady, my lord. And your lordship, the petitioner is the owner and possessor of a plot of land measuring, my lord, 3 biga. 3 kattha and 10 lichas, my lord. Initially, my lord, she had 4 bigas of land, my lord. But my lord, 1 kattha 6 lichas were acquired for the national highway, my lord. Initially, she was the owner of 4 bigas of land, my lord. 1 kattha 6 lichas, my lord, went to the national highway, my lord. They acquired, my lord. And now, my lord, recently the petitioner was constructing the boundary wall on the eastern side of the village road, my lord. So, my lord, the basic fact of the case is that, my lord, the Gaon Buddha approached this petitioner to give in contract the construction of boundary wall, my lord. We denied, my lord. Then thereafter, my lord, he in connivance with the respondent number 4, my lord, has issued a notice. But the notice is not in the name of the petitioner, my lord. It is in the name of the nickname of her husband, my lord. The notice, my lord. Now, I'll take your lordship to page 18, my lord, the sale deeds, my lord. There are two sale deeds, Kacha Patta is there, periodic Patta is there, my lord. Page 18, my lord would find, this is the first sale deed that was executed on 15th day of June, 1989. And from Jiblal Sharma, my lord, this petitioner, my lord, purchased a plot of land, my lord. And my lord will find the schedule at page 20, my lord. 2 biga, 0 kata, 0 lichas, my lord. Now, my lord, the second sale deed at page 21, my lord. In this, my lord, she purchased from Ranjit Dhar, my lord. This petitioner, my lord. And the, my lord, schedule is at page, my lord, 25, my lord. Thereafter, my lord would find page 26 are the, my lord, Kacha Pattas, my lord. Page 26, 27, my lord. Thereafter, my lord, page annexure C, page 30, my lord, are the periodic Pattas, my lord. These are the translated copy, my lord. And page 32 is the vernacular, my lord, Patta, my lord. Page 32. And page 34, my lord. There are two Pattas, my lord. Page number 32 reflects 2 bigas, my lord. And in the page 34 also 2 biga is reflected, my lord. And the statement, my lord, placed that 1 kata and 6 lichas, my lord, went to the national highway. That statement I made in the petition, my lord. And thereafter, my lord, from page 36, lordship would find the revenue receipts, my lord. Page 36. Thereafter, my lord, find a notice, my lord, at page 48, my lord. Page 48, my lord. This was the notice issued to Sri Saponpal. My lord, the husband of the petitioner is known by Saponpal also, my lord. Now, my lord, may I read, my lord, the notice? With reference to the subject cited above, it is very regretted to inform you that you are obstructing the Gautam Basti to Sukajan Bormati Road by constructing a boundary wall within the formation width of the road, and thereby the road became narrow to the road user. It is for your information that this is an intermediate lane, blacktop road, and it has 5.5 m carriageway with 9-meter formation width. Within the formation width of 9 meter, no construction is allowed. But as per field visit on 2nd Feb 2024 at Gautam Basti, it is observed that you are constructing a boundary wall and just near the hard thrust of the road, even at some portion of the blacktop road is being destroyed, which is illegal act of the damaging the public property. Hence, from now onwards, you are strictly instructed to stop further construction of the boundary wall within PW reserve land. Whatever you have constructed till date, you are instructed to demolish and remove the same from PWD reserve land within 3 days from the date of issue of this letter. If such activities are found in future, legal action will be initiated against you. Now, my lord, prior to this, my lord, no show cause notice, neither any notice was given to the petitioner, my lord. That apart, my lord, the notice does not show any schedule of the property, my lord. That apart, your lordship would find I have placed the photographs, my lord. The first photograph, my lord, annexure E, my lord, page 49. Your lordship would find that the pillar is outside the, my lord, tree which was cut, my lord. Then, my lord, that thereafter, my lord, will find the cemented, my lord.
The page 50, which one? Right side or left side?
My lord, the left side, my lord.
You also don't construct. Don't proceed.
I'll not proceed till then, my lord.
I'll take the instruction, my lord. Regarding part, my lord, demolition part
also.
my lord, status quo, my lord, in respect of that, my lord. And whether he has taken the permission from the town committee for construction of the road, not whether the 15, my lord, feet from the road, my lord, whether he can construct, my lord, all those points.
Because otherwise, this is not preceded by any show cause.
My lord, my
At
lord.
least it should have.
My lord, my lord.
And that too not with to the
My
petitioner
lord,
also.
demolition part, my lord.
That too not with because of
There shall not be.
Not to construct any further, my lord.
my lord.
Yet you are in a petition. And Mr. J. Sutia,
Correspondent number 2 and 4.
Standing Council, Carving or Permanent Council for the respond number
2 and 4.
Also heard MS M. Bormon, Land Engineer Government Bukit Assam for the respondent number 1. Chief Secretary.
Chief Secretary.
You serve a copy to Chief Engineer, right?
My lord. We have
Standing council is
given
there.
the copy to the PWD also, government of
council.
Assam also, my lord. We
Standing
have served copy today also. And
No,
separately
there-
also we'll serve it, man.
In the, was this one?
We have
Was this
given,
one?
man. We have served the copy to the standing council, PWD, my lord.
Production list of this one. Name is not shown.
But my lord, otherwise we have served, my lord. The notices are there.
Sir,
Yes, my lord.
the petitioner has claimed that she is the owner of a parcel of land covered by periodic patras. Full stop. Petitioner has assailed an order dated 3/2/2024 NXRD issued in the name of one Sri Sopan Paul under the hand of the respondent court by the said order, comma, the noticee has been instructed to stop further construction of boundary wall on the allegation that such boundary wall is being constructed within the reserved land of the PWD. So the order further mentions that has further directed the noticee to demolish and remove the boundary wall from the reserved land of PWD within 3 days from 3/2/2024. Mr. Tiwari and Council for the petitioner has submitted that the boundary wall is being constructed within the periodic patha land of the petitioner. The order dated 3/2/2024 was not preceded by any show cause notice. And as such, comma, no opportunity was provided to the petitioner before passing the order, comma, to represent the case of the petitioner in support with the supporting documents that the boundary wall is being constructed within the periodic patha lands of the petitioner. So moreover, comma, the notice was not served upon the owner of the periodic patha land. Rather, comma, it was served served in a name of one upon pot, comma, by which name the husband of the petitioner is known. Mr. Sutiel and counsel for the petition, standing counsel for the AAAC, has submitted that the matter whether the petitioner is constructing the boundary wall within the periodic patha lands of the petitioner or in the reserve, encroaching upon the reserve land of the PWD is a matter which requires factual examination. He has submitted that he will obtain instruction whether any opportunity of hearing was provided to the petitioner prior to the passing of the order,
and to permission from the authority or not for consent.
and whether prior to undertaking the construction works of the boundary wall, comma, any permission from the competent authority was obtained by the petitioner or not. Issue notice returnable on 26/2/2000.
4 weeks, madam.
4 weeks.
4 weeks. So that the private respondent is there.
Okay. Who is he?
The Gaon Buddha, my lord.
Yeah, Aura is not a rat. You're bringing
So the-
some
if the notice
personal
is-
dispute, no?
If the notice is issued, that 4 weeks, madam, otherwise,
Oh, why this?
60.
Because my lord, he.
We are not deciding. We only decide action of state
Yes,
authority, not deciding some instigation by private individuals.
So, my lord.
Okay, I should notice as MS Bormon and Mr. Sutia has a clear and accepted notice on behalf of the student. One, Aru, no formal. The Learned Counsel for the petition shall also serve a copy of the petition along with annexer, to Mr. Gogoi, B. Gogoi, Learned Standing Council, PWD, for the response number 3. So Mr. Tiwari has further submitted that the presence of the response number 5 is not necessary for the purpose of deciding the validity and legality of the order dated 3/2/2024. As such, the name of the petitioner, respondent 5 is to be deleted. Full stop. The prayer of Mr. Tiwari as regards deletion of the name of the respondent 5 from the array of respondents is allowed. The Learned Counsel for the petition, Mr. Tiwari, shall submit an amended clause title in terms of the clarification before the registry by tomorrow. By within 2 days. Para. Having regard to the projections made by the Learned Counsel for the parties from both the sides, it is observed that till the returnable date, both the contesting parties shall maintain status quo as on today. Full stop. It is made clear that neither the petitioner shall undertake any further construction work as regards the boundary wall, nor the respondent authorities shall undertake any action for demolition or removal of the boundary wall constructed till today. Constructed by the petition, till today.
Deeply obliged.
The respondent's name will be reflected. Other respondent's name will be reflected.
A name of the Standing Council, PWD, and ZA Assam will reflect in the respondent side in the corpus.
Deeply obliged.
Any other any other matter? Yes. Any other council waiting for some case? Thursday given. Mr. Locker, maybe you may I request sometime day after tomorrow. 3 o'clock. What is your next date?
My lord, do you have taken time, my lord?
Then we'll fix it on 13th.
30.
Tuesday. I thought of 9th, but it will be counted.
No issue.
It's awkward.
15 or so.
13th. Nothing to be hard actually.
Thanks has already been recorded.
You give your associate here at 3 o'clock. We observe.
Lord.
Mr.
I am Juddin.
and Mr. P.S. Kapoor. P.S. Kapoor. Place the case again on 13th for parade. The matter is likely to be taken up, if possible, at 3 p.m. Yes, anything?
In this matter, my lord, as per last order, we have to apprise the court regarding applicability of the consent rule, my lord. We need some more time, please, 3 weeks time, my lord.
The learned counsel for the petitioner is absent today on call. Mr. N.K. Sharma. No, Mr. M.S. M. Mormon. Junior Assam for the respect number 1 and 2. And Mr. N.K. Sharma. Learned counsel representing Mr. N.K. Das. Learned standing of the GHC for the respect number 3, 4, and 6. Are present. M.S. Mormon has sought further 2 weeks time.
3 weeks.
3 weeks time to obtain instruction in deference to the order dated 8/1/2024. So the prayer made by Joel is allowed. Is the case on the sheet. Deeply obliged, Lord.
Item 7.
Senior Advocate Biridas on his way kindly pass over with the
Over the respondent. But how much time did you take?
5 minutes.
No, arrival of Mr. Das, no matter.
Sir, senior, lordship senior is on legs now. So,
Senior, your senior.
M.K. Sudri, I have seen
Legs.
legs.
Let him come, my lord. In the meantime, the last question also.
No, I have to rise also. That is why. The other part which I have to dictate. That I have myself taken time. So any day, 13, 13, 13, 13. This 13.
13.
We are on 6, 13.
Yes. It was hard in fourth court matter. Fourth court, it was hard. My lord.
Oh, I have not looked into the file till now.
13-2.
13-2. Mr. B.D. does. As agreed to by Mr. B.D. does, learned counsel for the senior counsel for the petitioner MS
And Dr.
Learned counsel appearing for Mr. M.K. Churi, learned senior counsel for the respondents. Please the case on 13-2.
Yes.
For hearing Madam Paul, I am there.
Learning counsel is on legs, my lord.
Who?
KP Pathak.
Huh?
KP Pathak.
KP Pathak. And someone on the prayer of Mr.
W. Ahmed.
W. Ahmed, learned counsel for the petitioners. Come on. Matter 2013-11 matter. Release the cases from particular date. What is the subject matter?
7-3.
What is the subject matter? Between the parties. Okay. Land dispute.
May I please your lordship? Lordship, in this matter, on the last occasion, lordship was directed to reflect the name of Mr. H.K. Das, lordship, in GHC, lordship. Lordship, we have not received the copy also, lordship, till date, lordship. Lordship, if the petitioner is also absent, lordship.
In this matter, I am appearing for pro forma respondent number 7 and 8. But we have no role in it.
Sometimes In the movie, there is no rules except appearing. So
That is right.
for some actors.
Yes.
So you be there like that. Will not strike out your name in
Yes,
the
yes,
absence
sir.
of the
Yes,
petition,
Lord.
right?
We will appear.
As in, when the counsel for the petitioner will appear, you make the submission. If he agrees, will strike off your name. There is no representation on behalf of the petitioner to the on call. M. Mormon. So it's 1, 2, 3, 4, 5, and 9. Oh, you are?
And I
Okay. And Mr. Anai Khan, learning counsel for the response number
7 and
5, 7, and 8 are present. Mr. N.K. Sharma, learning counsel, appearing on behalf of Mr. H.K. Das, learning standing counsel, DSC has submitted that the name of Mr. Das, learning standing counsel, DSC, has not been reflected.
No, Lordship. This is not a
Reflect-
problem.
Lordship.
We have not received a copy also, Lordship. That's why we have
Okay.
not, we are unable to
Okay.
take instruction.
Okay. Submitted that the copy of the repetition and the annexers, along with annexers and other pleadings, have not been, sorry, the copy of the repetition along with annexers has not been served, has not been received till date, has not been received from the petitioner till date. As the learned counsel for the petition is found absent to the on call, let the case, for eventual justice, be listed.
dispute regarding a missing stake.
Huh?
Dispute regarding a missing stake. And the
Missing?
case is missing stake, Lordship. From
Missing?
the custody. Stake.
They have alleged that from the custody of a CGM, Lordship, the original check was missing, Lordship.
But the case
Stake.
is stake, Lordship. The case is also pending in district consumer dispute.
Deeply obliged, Lord.
Yes, sir.
5th of March.
5th of March. Okay. As so for Mr. S. Sharma, learned counsel for the petition, MS.
Ebora,
Ebora, learned
NH,
standing counsel,
NH.
NHA, NRHM or NHM. For the response number 2. And M. Bormal and Junior Government Book Assam for the response number 3. Is the case of 5. In the top of the list.
Any 2014.
14 matter to the top of the list category.
Item number 13.
Mr. N.K. Sharma representing Mr. Counsel representing Mr. H.K. Das, standing counsel DHC is present as the standing counsel for the petitioner is found absent to the on call. Let the case be listed for ensure justice after 2 weeks on a date to be paid office.